To principal seat for pronouncement of judgment, item number 1.
Petition allowed.
May I, Lordship?
Yes,
I beg to mention item number 6, Lordship.
6.
Yes. Kindly,
Here we have filed our IA also for suspension of the judgment, my lord.
Item 6.
Item 6.
It's there. Item 6. IA is there. IA
Yes,
85 is there.
we have filed IA also. They are taking time, on the last occasion also they have taken time. Since the learned senior counsel is from Guwahati, but at the same time there is a contempt matter also pending for in the same case, my lord. At least the IA may be taken up, my lord. Prima facie, if there is a case that it can be stayed, my lord. They are pursuing the contempt matter as well, but taking time in this.
Lordship, in IA, this ex gratia is their compensation. It's important. Department have to audit.
They're saying that the policy, it's not applicable.
Lordship, in single bench, the order has already passed for the payment.
It's all right.
That's why we are
they
on
filed an
appeal.
But Lordship, the matter may be kindly.
In that case, if they want to take time, that's
next week.
but
Next
In that case,
week.
IA may be hurt, my lord. The
Next week. Problem
Oh.
is our senior is not available.
Senior is not here.
Next week or Friday. Friday.
Friday.
We'll take it up from Friday.
Friday.
Because the contempt, I remember contempt is also there.
Yes, contempt is there. They are pursuing the
Contempt is
contempt.
there.
Friday.
Friday.
You inform your senior.
This
Yeah.
Friday.
Or else if he cannot come, you
Can
are
I
good-
fix the
you
date,
are good or
Lordship?
better.
Can
Huh?
I fix the date? Can I fix the date?
Friday.
No, on 28th
Huh?
of July next month of 28th.
No. We have fixed the contempt matter after 2 weeks.
Oh.
Friday, this Friday.
Okay.
All right.
Oh.
20.
Yes.
This Friday. Huh. On the prayer of MS London Council for the respondent. And prayer not being objected to by Mr. N. London additional advocacy for the state appellant. List this matter on 20/06/2025.
All right, ma'am.
Yes,
And we have to mention by the item 12 matters.
item 12.
Last week I was directed to take instruction matters, so I could not get the instruction matter. May I pray that this matter will be taken up after the break matters?
After break.
Break matters.
We thought we'll dispose of the matter today.
Oh, my lord, next week then, madam.
Huh?
Next week then, madam. No.
No, we have no difficulty. If you agree.
In that case, let it go after vacation.
Okay.
Before vacation, it might be difficult.
On the prayer of Mr. R.C.K. Land Council for the petition and prayer not being objected to by Leonard Advocate General for the state. List this matter after 4 weeks. We'll say after 4 weeks.
May I please, my lord?
Yes.
I beg to mention item number 1, my lord. The leading counsel for the petitioner is out of station. So matter may be list after.
Every time when the matter is listed, leading counsel is somewhere other, some other practice you are taking time. We'll dismiss that PL. What's there? Who's Entaze?
Yes, L N doesn't.
What about Sonar?
He is supposed to be back to the, but
This is the challenge. Challenge is to the rule of other thing.
Act.
Entrepreneurs back.
But in item number 1, there is an order that the issue of maintainability will be taken up.
Problem is
Huh.
leading counsel is not.
I leave it to your lord. I
When
cannot.
do you want?
your matter may be list after vacation. Your
Hmm.
So let the leading counsel may be.
Hmm?
Leading counsel may become. So I'm not
What
much
is
aware of this.
item 2?
2 has to be heard on merit, but 1 first maintainability has to be decided.
I think 2 this court, one of us may not. There may be a
Perhaps.
Yes, absolutely.
Time for item number 2. Here, from our side, only final hearing is remains.
I cannot take up this matter, item number 2,
Yes, yes.
right?
Yes, both are connected. Both are connected.
Both are
Yes,
connected. In that case,
In that case, your lordship will simply say that
yes. List these matters before any other approving bench without one of us, huh? What the best?
I'd like to mention item number 9. 9, your lordship. Because of the appellant Embagra is sick, your lordship.
He's sick.
Yes, lordship. So lordship may kindly adjourn the matter and release it after 3 weeks. Consent has been spoken from opposite
On the
party.
ground that learned legal aid counsel, Mr. Ember, is seriously sick, Mr.
Tina, your lordship.
Mr.
Yes, lordship.
Your name, please.
Tina, your lordship.
Then counsel press for adjournment of the matter for 3 weeks. 3 weeks.
Your lordship, 3 weeks. After the break, might be.
4 weeks. Considering that the learned legal counsel is not keeping well, let this matter be listed after 4 weeks. Not at all.
Item number 3.
Time for the respondent number 1 and 2.
Yes, have you filed the affidavit?
No, my lord. In fact, main respondents are, my lord, respondent number 3 and 4, man. They are the main respondents.
My lord, this is matter relating to item number 2 or 3, my lord.
Yes, Martha. Yes.
I am for the item number 3, my lord.
Hmm.
My lord, the main issue is, my lord, here, my lord, relating to the non-consideration of my qualification. That is, my lord, the B farm with the MTech in the biotechnology. That was in otherwise in earlier occasion in the under the my lord AICTE. That was a qualification to be recruited and work as a lecturer, then for promotion in all the pharmacy colleges. We were imparting the diploma as well as the degree. But after the enactment of the regulation, that is the minimum qualification for teachers in the pharmacy institutions in 2014. Well, that qualification was not inserted. For that reason, my lord, although my lord, we are allowed to continue in the service because of the one of the minute of the pharmacy council meeting that was held in 2007. But our consideration for promotion to the director, either or the principal or any SOD, that was not considered.
Very difficult.
So in that,
We're not getting anything.
my lord, I am audible, my lord.
You
I
are
am
audible,
my
but it's not clear what you are submitting. We're
my
not,
lord, in this, my lord,
we're
in
not,
this case,
we're not able to make out anything what you are submitting.
my lord, my case is this, my lord. Our qualification that is in, my lord, B Farm degree with, my lord, MTech in biotechnology. That was, my lord, the earlier that was a qualification for appointment as a lecturer, as a professor in the all pharmacy institution imparting diploma and degree courses. In earlier, my lord, as per the AICTC, my lord, regulations and terms and conditions of the qualification. But the subsequently on, my lord, enactment of this regulation that is called the minimum qualification for teachers in the pharmacist institution, that is complying the provision of section 10 and, my lord, 18 of the Pharmacy Council Act 1948. My lord, in regulation 3, where, my lord, our qualification has not been inserted as one of the qualification to impart the education. Although, my lord, we are allowed to continue as per the, my lord, minute of the Pharmacy Council meeting held in 2007, by which allowed to continue because we have been appointed an earlier system of, my lord, recruitment rules and, well, provisions and qualification. But our consideration for next promotion to the director, either or for principal or SOD and professor, that was not considered. So this is the case where I am challenging the Pharmacy Council regulation. And in that respect, already respondent number 4 has filed their affidavit, but the respondent number 1, 2, and 3, but main, my lord, respondent number 3 has to, my lord, respond in these things, because the affidavit filed by the respondent number 4 specifically stated that they have, in person to Supreme Court judgment, now the pharmacy councils and the AICTC has been bifurcated. So this entire, my lord, this domain of my qualification and other things to be considered by the Pharmacy Council. This is my case, my lord. So I am challenging because we are already appointed, we are already working as per the earlier qualification, but our qualification not been included. It is lordship will get in page, my lord. I have annexed report is the all the provisions. It is, my lord, lordship will get at page, my table, my lord, page number 16 of my petition, where, my lord, I have table the, my lord, minimum qualification for academic qualification. Page number 16. Page 16. 16. 16. Yes, my lord.
No, we
It
have
is
understood,
started
yes, but then how do, yes, Mr. Mahanta, how do we direct them to,
Yes,
how can we direct them to include
No,
or
no, my lord,
exclude,
my lord, yes. Yes, my lord. Our fundamental right. I have been, my lord, infringed because of
what
this
is your
illegal act.
fundamental right?
My lord, because my qualification that to be considered one of the qualification for imparting education
That is
in
what
the pharmacy
other,
colleges, my lord.
that is the other
This is my case, my lord.
That
This
is
is my
different.
case. We are not appointed.
Sir, that is different issue. But then, how can we direct the authorities to exclude or include qualification in the
No, my lord,
regulation?
my lord, lordship have to scrutinize the things whether that have been done illegally. Because lordship come to page, my lord, annexer, my page petition 17, my lord. The qualification, how they enter, all qualification they entered. Even the MBBS and the other engineering degree and maths also they included. But the Pharmacy Council, my lord, did not enter our qualification. It is, we are B Farm graduate and biotechnology MTech. This is one of the course curriculum to be imparted, to be studied, to be, well, imparted in the course of the pharmacy education. So this is our qualified. We are still imparting education, but our promotion is not considered, my lord. If we are allowed to continue as a lecturer, we are giving the benefit of this associate professor. Then why we should not be considered as a promotion? At this stage, my lord, the Pharmacy Council has to respond.
Yes, want to file affidavit.
In fact, correspondence has already been made to the ministry. There is no matter is now instructed for this. So one opportunity may be given, I will take instruction.
Yes, Mr. Mahanta, it's very difficult.
My lord.
Number one, your submission were not able to make out anything. So we request, we'll take it up on some other day. Request, come and physically make your submission. All right.
Okay, my lord. But problem, my lord, some
This
communication, my
is
lord.
very difficult. Number one, and
Yes,
you are too fast.
So,
You are faster than a bullet train. And the respondent is also seeking some more time. All right.
all right, my lord, I am obliged, my lord. I am
Heard,
obliged, my lord.
Mr.
At this, my
P.
lord, maximum I get-
Mohan, counsel for the
ultimately
petitioner. Mr. M. Kato, learned DSGI, praise for in is granted
For one issue, my lord.
further 3 weeks time to file affidavit.
My lord, date may be given, my lord.
List as agreed to by the learned counsel to the parties. List this matter on when do you want?
My lord, after 3 weeks, no?
Yes.
July, July, my lord, last part of the July, my lord. July, my lord, July.
21st.
20,
No,
20,
22nd, 22nd.
mass obliged, my lord. Mass,
22nd.
mass obliged, my lord.
Biplab.
This legal aid counsel. Where is Mr. Gini? J. Gini, legal aid counsel. PP also, PP? When the method is followed, neither the legal aid counsel nor the learned PP is present. List the matter after 3 weeks so as to enable the legal aid counsel, learned legal aid counsel to take steps as directed by this court on 09/04/2025. Item 4.
I apologize, Your Lordship.
Actually, last on 9/4/2025, the
Yes.
legal aid counsel was directed to
File,
file condemnation.
yes,
for-
appropriate petition for delay, condonation of delay.
Yes.
But this has not been filed as on date, my lord.
You inform him.
Yes,
It's
Your Lord.
clearly given. He, on his submission that he could not travel to jail and all, the court has directed the steps.
Okay, I will communicate him, my lord.
Just communicate. But listing after the 3 weeks.
Okay, Your Lordship. Oblige.
Number 5.
My lord, here, I know. I number 202 is here.
Huh?
IN number 202 is there
Ah,
for continuation delay of for the
that,
period
that has already been condemned.
3 days.
It has been already condemned.
Not condemned.
Has been condemned, sir. Please clear your mouth first. Sir, first clear your mouth. Go out and clear your mouth first. You are a seasoned
My
lawyer.
lord, my lord, I'm
Very senior lawyer. How you are
my lord, sorry.
conducting
The
yourself
IA
like this?
number 202 for the continuation of delay for the period of 3 days.
That has been condemned on 12/6/2025. So the order. Very unfortunate.
My lord, in that case, I'm very much obliged for that. And
Was
In-
the question of oblige? First, check the records.
Service of respondent in respect of the my lord, the last time. My lord,
Sir, are you in your normal sense?
yes, my lord. Yeah, yes,
If you have difficulty, we'll adjourn the matter.
no, my lord, I'm
Don't-
okay.
don't be-
Now in regards to the main appeal, copy has been not served to the respective respondents.
See,
Hmm.
delay has been condemned. You argue the matter. We're hearing you. Mr. Neighbor, we're repeating it. We're giving you a chance. Are you in your normal sense? Do you have any difficulty today?
Actually, I'm not today. I'm not ready for that. It was just I was approaching for the IA, so I was not prepared. If tomorrow,
We should not say this, but you appears to be under hallucination.
my lord,
We're very sorry. Forward, we'll hear you.
tomorrow, my lord, matter maybe
It's not all your
yes, that is
convenience.
my lord. I may be given 2 weeks times.
Day after tomorrow, Thursday.
Day after tomorrow. Okay, my lord.
I think you need to see a doctor. Are you
Okay.
sure?
Okay,
Day after tomorrow. Hmm?
I'm seeking for 2 weeks. If day after tomorrow,
On the prayer of Mr. M. Nebo,
Yeah.
Learned Counsel for the appeal and list this matter after
2 weeks, my lord.
4 weeks.
Obliged. Most obliged, my lord.
MS G. at the Learned Edition of Senior Government is present.
May I have your lordship? This case is for restoration of the writ appeal number 10 was
Ah.
dismissed for default, your lordship, by
Ah.
order dated 22/4/2025.
Yes.
It was default on the part of the council on my part, my lord. That's why my humble prayer is that, my lord, this writ appeal may be restored. It may be adjudicated in its own merit.
Yes, what is your ground?
My ground is that, my lord, it is fault on the council, part of the council, because it was inadvertently we could not notice in the cost list. Because of that, it was dismissed for default, Your Lordship.
For all, not once,
Was it?
on many dates,
Yeah, no, 2 days, man.
2 days.
2 days.
One can understand if it is.
It was
for one-
not in 1 date, it was in 2 consecutive dates. Because of that, yes. Okay. It was first listed on 12.
Yes, what you say?
My lord, otherwise also appeal, writ appeal, there is no any case.
No, there is one thing.
No, no, this can be restored with some cost.
What is the matter?
Matter is regarding, there was direction from the High Court to the PWD department. There was diversion of the alignment by the highway. Then there was direction from High Court in PIL to construct similar road, but they kept abandoned the roads PWD. And on the request of the Honorable MLF, RWD, they proposed PMGS road. They constructed PMGS roads. So they challenged that NIT. Now road is completely long back. So on the basis of the
One connected matter is also pending before the principal seat.
Yes.
I think contempt matter.
contempt is there, contempt.
Contempt matter is pending. This regarding a construction of what?
Okay.
Restore it and we'll see.
With
On
some
what
cost.
merit, huh? On merit, we'll see.
Yes.
We'll consider on merit.
Yes.
Not Mr. D.K. Devi, learned counsel for the applicant. And also not Mr. G. Tarak, learned standing counsel for
RWD.
RWD. And MSG at learned
For 2, 3 and 7.
learned additional senior government advocate for the respondents. Next paragraph. This is an application for praying for restoration of writ appeal number 10 of 2024, which was dismissed for non-prosecution by an order dated 22/04/2025. Having considered that the engaged counsel is from outstation lawyers have inadvertently missed the date when the matter was listed. And the prayer for restoration not being objected to by learned counsel for the respondents. We deem it appropriate to allow this application. But as the due to inadvertent miss of the date for listing matter by the council, which shall not be prejudice to the appellant from appellant, Mr. Accordingly, the writ appeal number 10 of 2024 be restored to file with a on subject to payment of
Yes.
5,000 rupees as the cost.
2,000, your lordship.
5,000. The cost shall be
To the bar association.
huh?
To the bar association. was-
Why bar association? Why not legal? Okay.
No, bar
Shall be
association also
deposited
some crisis.
before this court and thereafter be dispersed. The subject to payment of the so and so, which shall be deposited in the welfare fund of the bar associations. Guwahati High Court Eternal Permanent Bar Association.
Yes. Apply.
This matter, my lord, while disposing of, your lordships had expressed the expectation that it will be done within 6 months. So we are praying for, considering the fact that the issue is slightly sensitive. We are praying for some, your lordship may just modify that observation.
Could have come before 6 months. And in fact, this is on your submission only. We have not
In
decided.
fact, there is no
we have
direction
not
also.
we have not decided anything.
Yes,
You said you want to do it within 6 months. We
Look.
agreed.
we tried, my lord, your lordship is aware, slightly sensitive situation. So it's not that we are not doing it. We'd like to have take them into confidence and then do it now. In fact, that is exactly what we have stated in the IA also. That your lordship peruses the IA, contents of the IA. Paragraph 3. In fact, well, if your lordship peruses the order, it was not really a direction. Your lordship had expressed the expectation.
No, it's as good as direction because you have agreed to.
Direction
on
to
your-
frame the rules. But
Yes, on your submission only we have.
yes, I agree. I agree. At that time, we could not visualize the situation properly, perhaps.
Yes.
I have serious objection, my lord.
Yes.
The submission, my lord, saying that this is sensitive, my lord, this is not tenable, my lord. If my lord, the executive, my lord, is unable to carry out the command of the legislation, my lord, then there is a consequence in the constitution, my lord. There is a consequence, my lord.
Huh?
There is a consequence, my lord. If executive is not unable to implement the command of law, my lord, there is a consequence, my lord. That need to necessarily follow, my lord.
Command of what?
Consequence is, my lord, if they are
No,
executive
cannot
and not,
take-
pardon, my lord,
Whose command?
of the legislation, my lord. Now, this is command of the legislation, my lord. This until and this is repealed, my lord. This need to be there need to be framing of the rule, my lord. Now, in terms of that, already order has been passed, my lord. I
Sir,
humbly,
we're not getting it.
no, my lord.
What do you want to say?
There is a
Are
la-
we supposed to, I mean, go by the command of the legislature?
no, my lord. No, my lord. What they are now saying, my lord, we can implement this, my lord.
They are not
Sir-
saying, they are saying, give us some more time.
The time, my lord, already expired, my lord, or already 3 months expired.
That's why they are seeking time.
That's
Had
why,
it not been expired, they would not.
that's why I am making objection, my lord.
Huh.
There is a command of the legislation, my lord, to frame the rule, my lord.
Huh.
Now, judiciary, my lord, can executive, my lord, can withhold that, my lord. I humbly believe, my lord, under the constitution, my lord, once there is a command of legislation, my lord, that cannot be withheld by either by the executive or by the judiciary. So this need to be implemented, my lord. There should not be any time extension. Sensitive, my lord, cannot be issued for, if they are saying that we cannot implement, they are pillar of the, pillar of the constitution machinery, my lord. If they are saying, my lord, this is sensitive, then they cannot implement this, my lord. They are not fit to be in the governance, my lord. If they are saying so, my lord. That cannot be granted. So my humble submission, my lord will not give time extension, my lord. Already 3, 4, 6.
Why it should not be?
Because, my lord, this is a command of the legislature, my lord. Now that by executive and my lord, judiciary, my lord, cannot by way of order cannot subvert the command of the legislature, my lord.
What do you want?
I pray my
They
dismissal.
have expressed whatever may be justified or not, they've expressed. They could not do it. They wanted to do it. Due to certain, I mean, ground reasons, they are not, they could not do it. They want some more time,
Yes, my lord.
right? And that's why you want that it should have been done, it should be done. What would be consequences in that case? Admittedly, they have not done it.
Therefore, I am saying, my lord.
Are you gearing up for further proceedings? Another proceedings?
No, my lord.
Are you gearing up for another proceedings?
No, not proceeding, my lord. I am praying for dismissal of this IA, my lord.
Then what will happen?
Pardon, my lord.
What will happen? What will be the consequences if we dismiss this IA?
I will take the appropriate legal part of legal remedy, my lord, available, my lord.
How the law are, for what the laws are being legislated? Parliament and Assembly, how they, why they make laws?
For the public, my lord.
Then
Yes, my lord. Now that's why I am saying, my lord, there is an existing law, my lord. Now executive and judiciary can be, yes, my lord, repealed in as per the law constitution, my lord. Not by this way, my lord. Not by interpreting the legislation by extending a time, my lord.
no, they are not saying that they want to do it, but they said due to certain reason they are not able to do it.
No, my
So
lord,
they are
that cannot be
seeking
acceptable.
some more time.
That cannot be acceptable, my lord.
Why that cannot be accepted?
Because, my lord, I say there is a existing legislation, my lord.
Yes.
Now that there is a command, my lord.
Yes.
Now that command may not be subverted by this way, my lord.
They are not able to do it within 6 months.
Yes, my lord.
They want to
If
do
they-
it.
they are-
They want to do it, but they could not do it within 6 months.
Yes, if they are not able to do these 6 months, my lord will not support them, my lord. My lord will not support them, my lord. If they are not,
Question of supporting.
now, if my lord extend the time, my lord, some way, my lord, that will directly indirectly supporting them, my lord. Therefore, my lord, I pray this will.
There's no question, sir. How you are trying to undermine
No, my
the
lord.
power of this court?
No, my lord, I am not. I am saying,
They
my lord.
file an application. We're considering. We're hearing you. We're considering. What's the question of acceptance, not acceptance?
Yes, my lord.
If you find that there's a reason to accept the application, we'll allow it.
Yeah, but that can be, yes,
Do you want every application by the government should be rejected?
no, I'm not saying so, my lord.
Whatever your application,
I'm making my,
we decide on the merit. As per the law, we decide. The private litigants, as well as the state also litigant, we equally treat you equally.
yes, my lord, equally, my lord. But situation here is, my lord.
So it doesn't mean that the private person filed an application, we should accept it. If the government files an application, we should reject it.
No, my humble submission, my lord. It is a case. It is a case. Here, there is a legislation, my lord. That is one part of the
Legislation was done long before, 47 years, 48 years.
Yes,
back.
my lord. That is
It was
no,
not done.
now.
Now, what is the urgency, by the way? What is the urgency according to you?
My lord, my humble
It
understanding.
was not done for
my
47
humble
years,
understanding,
48 years.
One, there is a legislation, my lord. There cannot be question of urgency,
That
my
is
lord.
true, that
That
is
is
true.
the command of the law, my lord. That need to be implemented executive, my lord. My humble understanding, my lord. There cannot be further debate on where there is a urgency, my lord. There is a sensitive, my lord.
No,
My humble
just-
understanding, my lord.
as you
Once,
know,
my lord, constitution mandate, my lord, the law is to legislation, my lord. Once that is in the place, my lord, that need to be
under the present
implemented by the
situation,
executive.
under the present situation, as you know, don't sound like as if you do not know
Yeah, but,
anything. Everybody knows. Now, what is the urgency? Can you just show
No, my,
some example? What is the urgency?
I humbly pray, my lord. I humbly pray. I am against all the discussion, my lord. What is the urgency, my lord? What is the sensitivity, my lord? My humble understanding, my lord. We are run by the constitution, my lord. The rule of law, my lord. The constitution was a mandate legislation by the legislation
So the
law by
proposal
the
for consulting
legislation,
the
my
people.
lord.
So the proposal for consulting the people, you have an objection.
47
not-
years,
not
my
to
lord.
consult.
Already, my lord, 47 years, this law has been keeping only in paper, my lord.
That is why I'm saying 47 years, 48 years, you did not, or nobody agitated. But now you see, they are seeking for some more months only in order to consult the people in the society. So what is the urgency now? For at least 3-4 months. They are seeking for 6 months probably. How much? Yeah.
In the prayer, we have said that a reasonable time.
Reasonable time.
Because,
Reasonable time. can be
Consultative
granted.
process with the.
See, it was an unreasonable time. 48 years. Nobody agitated.
Then, my lord, what would be the reasonable time, my lord? My only concern, my lord, is my lord, this is command of law, my lord. That need to be implemented, my lord. If they have a serious issue, my lord, they have a remedy, my lord. They can there can be a other process also under the
What is the
constitution,
process?
my lord. They can repeal it, my lord. If
Huh?
they so, they can go for repeal, my lord. If they are saying so.
Why not the advisor of the legislation?
Yes, my lord. That's why, my lord.
Why not the advisor of the legislation?
Yes, my lord.
What they should do and what they should not do.
Yeah. Well, that's why I am humbly praying, my lord. By this way, my lord, the command of legislature cannot be subverted, my lord. Their time extension, my lord. Once there's a command of legislature, that need to be.
My brother has pointed out, you have slept for 40 years. Suddenly you come and they are asking for extended time to frame the rules. What would?
My lord, I humbly believe, my lord, all this discussion, my lord, once there's a command legislation, my lord.
Heard Mr. I. Chaudhary. Yes. Who are extending it? How much?
We have said reasonable.
No, that cannot be too bad.
About 8 to 10 months, I think will take.
That will be too long.
Or your lordship may say that by the end of this year. We are all nearly in June, so another 6 months that we will get.
You will say 6 months. 6 months.
Man,
You should remember the laws are made for the people.
My lord.
We're not concerned about what's happening, what's not happening. We'll go by the documents, right?
My
You may have so many knowledge, personal knowledge, we don't go by that. All right? Mr. I. Chaudhary, Learned Advocate General for the applicant state, Arunachal Pradesh. And also her Mr. Helper, Learned Counsel for the opposite party, respondent, opposite party, public petitioner, respondent petitioner, respondent opposite party oblique petition. By filing this application on behalf of the state of Arunachal Pradesh, the applicant, and by the state of Arunachal Pradesh, the applicant has prayed for extension of time to comply with the judgment and order dated 3009/2024, passed in PL number 16 AB 2022. Mr. Next para, I Chaudhary, Learned Advocate General, while referring to the requirements made in the in this application, submits that the matter, since the matter pertains to framing of the rules under framing of the rules mandated under Section 8 of the Arunachal Pradesh Freedom of Religion Act 1978. Which was supposed to be, which the state was obligated to finalize within a period of 6 months. 6 months, however, when the matter was processed and multiple consultations were taken up among the authorities, there arose a certain misconception among certain section of the public and public wisdom. He submits that the state of Arunachal Pradesh comprises of several tribes and sub-tribes practicing different trades, and such a broader consultative process is likely to take a considerably longer period of time. And the issue being a sensitive one, the government is of the state applicant is of the opinion that in larger public interest, it is important to take the different sections of the society into confidence, which the process is bound to be substantially time consuming. Therefore, prays for a reasonable time to comply with the order of this court dated 30/09/2024. Next, Mr. Helper, Learned Counsel for the opposite party, writ petition. Vehemently objected to the prayer for extension of time on the ground that since the law has already the Arunachal Pradesh Freedom of Religion Act 1978 has been enacted 45 years back. And under section 8 of the Act, mandated for framing of rules which the state has miserably failed to follow the command of the legislation. He submits that the what more? They fail to follow the command of the legislature. Then
Pardon, my lord.
you said the state has failed to follow the command of the legislature.
Not implementing the order of the legislation.
By not implementing the command of the legislature. What they
My lord, in absence of those rule, my lord, this legislation, my lord, cannot be implemented, my lord. In absence of the rule, my lord, this piece of legislation, my lord, cannot be implemented, my lord. That's why, my lord, ultimately, this is by after framing the rule, my lord, this needs to be implemented, my lord.
he submits that. That's we find it very, unconnected. It's your submission may be correct, but so far as extension is concerned, we're not able to connect your submission with this.
No, my lord, my humble
application.
understanding, they are saying they are seeking, my lord, time extension, my lord, saying that this case is sensitive, my lord. Yes, issue is sensitive, my lord. Now, my humble understanding by Constitution is given whether legislation
They are
is sensitive
saying-
or not,
they
my
are
lord, that's
saying maybe
given to the
sensitive,
legislation,
whatever reason they said, whether consultation is required,
my lord.
right?
My lord. For that's why I am saying, my lord, once, my lord, law, my lord, now on legislature, my lord, on their own wisdom has legislated law, my lord,
Yes.
they cannot take that my ground, my lord, which is the I
No.
believe.
They are not saying they are not doing it. They just need some time to do it. All right. Taking the public interest, larger public interest, they want to have a weather consultation. That's why we have indicated, law is for whom? It's for the citizen, it's for the public. For you, for us, for everybody.
Yes, my lord. My humble understanding whether this law, my lord, is beneficial for the public
Okay,
or not, my
just
lord,
read
that can be
objective.
determined by the legislation, my
I'm
lord,
not
not by the
recording your
executive, my
submission
lord.
because it's not, we find it not connected. I've recorded that they have failed to follow the command of the legislator.
My lord.
That's why you have this thing. Anything else?
No, my
Having considered the submissions of learned advocate general as well as the learned counsel for the opposite party of the writ petition. We find that in the facts and circumstances, and we find that the grounds for grounds seeking extension of time to frame rule as maintained under Section 8 of the Arunachal Pradesh Freedom of Religion Act 1978. To be reasonable, as it is seen that the state of Arunachal Pradesh which comprises of different tribes, preaching different religions. Come on. The being a welfare state in a democratic polity, come on, requires certain procedures, including consultative process, which may take some time. We also take note that the Arunachal Pradesh Freedom of Religion Act 1975 was enacted enacted by the legislation, and even after lapse of 45 years of its enactment, the rules could not be framed as mandated under Section 8 for implementation of Act. The state has barely admitted and the state has taken steps and has initiated the process for framing of the rules. However, due to certain circumstances, it appears that the state has decided to have it, whether or a broader consultative process with the people, a consultative process with the public, which may be required in the interest of larger public interest, in the interest of in the larger public interest. Mr. In view of the above, we deem it appropriate to allow this application, granting further 6 months time to for taking appropriate steps as required to be done under the Arunachal Pradesh Freedom of Religion Act 1978. That will be all right. Suffice. Application stand allowed in this court.
Lord, in item 10 and 11, I am Naveen Kumar appearing through VC, Lord.
Yes, sir. BC, through BC, it's very difficult.
I'm sorry, my Lord. I'm
At the same time, we cannot refuse also.
no. I'm so deeply obliged, my Lord. My Lord is so kind. My Lord, the pleadings are not complete. Central government has been given 5 opportunities. Even last order also records that central government should file their counter without fail. So, my Lord has to I can't say, my lord, the central government should file and they should assist, my lord, so that matter can be heard and disposed of. My lord, my valuable rights are at stake, my lord. I have invested huge amount on prospecting and all that, my lord. They have accepted my report, everything is done. But because of center not filing their counter, I am held up, my lord. My lord, may refer to fourth and fifth para of last order. That is order dated 26 May 25. My lord has recorded 26 May 2025, my lord, fourth para. We have perused the material available on record and find that central government is yet to file its response in the matter. In the absence of said response, it would not be proper for this court to adjudicate upon the issue arising the present writ. Then Mr. So and so, appearing for so and so, submits that affidavit on behalf of respondent by him would be filed within a period of 2 weeks from today without fail. And this is, my lord, fifth order where they have been directed to file their counter, my lord. So, my
Yes.
lord should.
My lord, admittedly, the respondent number 2 has been, my lord, impleaded much after, my lord, the issuance of notice, my lord. Earlier, Union of India was not made as a party, my lord. Subsequently, it has been made.
Anyway, but then,
Now, my lord,
you
the
have
affidavit
taken-
has been
you have
received.
showed- huh?
My lord, affidavit has been received. There is some defects in filing, my lord. So, my lord, 2 weeks time may be granted, my lord, will, my lord, correct the defective, my lord, the person, my lord.
So what do you want, Mr.
I want hearing only, my lord. I can't ask anything more. So let their affidavit be taken on record, my lord. And
Do you agree that without the affidavit, it's difficult, it will be, it
No,
would
my
not
lord,
be
I will not-
proper,
I
it will
will
not
not-
be proper to adjudicate the
Yes.
matter?
Yes, my lord, their affidavit is necessary, my lord, because the central legislation
We are
is
raising,
involved.
So we'll
important
grant them
questions,
some more time. What do you say?
Yes, yes.
Within item number 12, item 11, which is a connected matter,
Yes.
that is a fresh matter. There we are also required to file our affidavit. So,
Item 12.
item 11.
Item 11. In that also I am appearing, my lord. Both matters deal with the same legislation, my lord. So let them
No,
file
in,
their
in that case, in both the cases you file, if it's connected matter, analogous, we'll take it up together.
One.
So we'll grant them 4 weeks time.
my lord.
All right.
Deeply, my lord. Deeply. But within 4 weeks, they should serve and with advance copy to me.
Mr. Naveen Kumar,
Naveen Kumar. Yes.
learned counsel for the petitioners. In both the cases,
Yes, my lord. Yes. My lord.
we'll not record that lost the thing. We'll just on your prayer. We'll just grant you a time. Yes, Mr. Although these matters are listed for hearing, since the affidavit in opposition, since the response of the respondents would be required for proper determination of the issue involved, and also as spread by the learned Advocate General.
In 10 we have filed long back. Only in 11 we are.
No, I said learned Advocate General and Mr. I. Chaudhary and Mr. M. Kato learned DSGI. Further, 4 weeks time is granted for filing response. Not filing for response. Mr. You file in both the petition.
My lord, I have received a copy of the, my lord, defective affidavit in respect of, my lord, item number 10, my lord.
What about 11?
11, my lord, so far I have not received any instruction.
You take it within
Yes,
our.
yes, in item number 10, we can file, my lord, the
Mr.
affidavit.
M. Kato learned DSJ shall file the affidavit in both the cases on or before the next date of listing. And the state of Arunachal Pradesh shall file their affidavit in writ petition 156 of 2025. List the matter after 4 weeks.
My lord.
My lord is giving any date, my lord?
You suggest
Can it be on 28th, my lord? I have some other matters also fixed.
28th July.
of July.
28th July. Yes,
List on 28
28
07
July.
20 27.
Deeply, my lord. Deeply. my lord.
May it please your lordship.
Yes.
My lord, I am troubling your lordship because of one urgency, my lord.
Hmm.
Matter relating to, my lord, the auction of coal block, my lord.
Hmm.
Namchik East and Namchik West.
Hmm.
In Namchik East, stays there. In Namchik West, this honorable court initially granted stay. Against that, they preferred appeal before this honorable court. This honorable court allowed respondent to continue with the tender process and finalize it, but shall be shall be subject to outcome of the writ petition. And one undertaking was also given by them that whatever the decision they will take, they will abide by the decision. In the meantime, my lord, today, my lord, yesterday I came to know that today they are going to issue vesting order, your lordship.
Hmm.
Vesting order means, my lord, they will allot coal mine, they can extract coal and they can sell. Whereas, my lord, we are ready to take that coal mine more than, my lord, double the amount whatever the other side has given. So, I have filed IA, my lord, today. It can be taken up at 2, your lordship.
You will see.
My lord, at 2.
It's not listed today.
Not listed.
Hmm. Yes.
Back to mention item numbers 20 and 21.
20.
Some few days accommodation, my lord. I've just been engaged in this case for the other petitioner. Can it be taken up?
20 and 21.
20 and 21. I've informed Balada Senior also.
Why this is listed for orders?
We have filed the
I
for my lord,
application of the
petition of the interim order, my lord.
Okay. So when do it?
Let it be on Monday, my lord.
Monday.
Depending for the first time, my lord.
On the prayer of Mr. D. Pang, counsel for the respondent, applicant,
no, my lord. Opposite party in the IA, petitioner in the
then counsel for the petitioner. And as agreed, and prayer not being objected to by Mr. RCK, then counsel for the respondent.
Respondent 5, my lord.
Respondent, applicant, and Mr. B. Pitcher, counsel for the learned standing counsel for RD, rural development. Huh? This matter on
Monday, my lord.
23rd. 23 06 2020. We'll dispose of the matter.
My lord, my lord.
It's a transfer posting.
Transfer posting.
May it pleases your lordship.
Yes.
My lord,
Yes.
I beg to mention item number 18, 19 and 22, lordship.
18, 19, 22. Yes.
And 22.
Hmm.
Lordship, if this matter can be fixed on 29th of July, lordship.
What is the matter? Why this has been listed
This-
today? Why this is
lordship
listed for
notice
orders
was
today?
issued. Lordship notice was issued, lordship.
Okay.
In all the 3 cases, notice were issued.
And
Private respondent had not appeared on the
Huh?
last occasion. Private respondent in all the 3 matters, lordship. It's a similar kind of matter. All the 3 matters are similar kind of matter, lordship.
there are
And
private
notices were
respondents.
issued. Yes, one private respondent is there.
What about the notice to him?
We have served the means we have taken the steps, Lordship.
Taken
And
steps,
since due to my
notices.
inconvenience, I could not.
Yes,
Since,
sir.
because of my inconvenience, I could not travel, Lordship. So I could not check
Madam,
the office note.
is the service complete?
That I could not check the office record. I apologize for that since I am out.
We'll see, we'll see.
Your Lordship, in item 18 and 19, on behalf of MS Standing Counsel for Election Commission of India.
Huh.
We have not received the copy yet, Your Lordship.
Okay. And
Madam, I am for the State Human Rights Commission, respondent number 2.
in item, this is 1819. Office note dated, heard MSD Ghosh, London Council for the petitioner. Next where office note dated 16/6/2025 reflects that service report in respect of respondent number 2, 3, 4, 5, 6, 7, 11, and 12 are still waited, still awaited. List of, you are for respondent number?
Respondent number 4, Election Commission of India.
MS so and so learned council for respondent number 4, the Election Commission of India. Enters appearance on behalf of respondent number 4, Election Commission of India. You furnish a copy to the Election Commission of
Yes,
India.
Lordship.
The
Yes, Lordship,
MS
will furnish
so and
that.
so learned council, the learned council for the petition furnished a copy to the respondent number 4. What about you?
Madam, I am for the respondent number 1 and 2, madam, in item number 18.
So you don't know, you
Yes.
don't want anything. You don't want a copy.
Yes, madam.
You have the copy.
Yes.
You file your affidavit.
I was actually ready, madam.
Ready. The Mr. So and so, Mr. M. Katu learned council. You are not as a DSG here. Learned council appears for. Learned council for respondent 1 and 2.
2 and 3, madam.
2 and 3. 2 and 3 is granted 3 weeks time to file affidavit. You also file your affidavit. Same. Same in item 20. Not 20. What is it? 18, 19. It says show me the 19. In item 19.
18, 19, and 22, Lordship.
In respect of phone number 3, 4, and 7 is office notes so and so, 16/6 reflects that service report in respect of respondent 2, 3, 4, and 7 are still awaited. Same. Respondent number 4.
Sir,
Item 19.
1819. Your Lordship. 1819, respondent number 4.
Okay. Same order in that case.
Madam, I am 18 in 22, madam. I am for the respondent number 2 only.
Item 19, 2 and 3.
2 and 3. 18 and 19, 2 and 3. 23.
The same order, but then here the respondent will be, service report will be different. There is 2, 3, 4, and 7. Here, item 19. And item 22.
Lordship.
22, I am for the respondent number 2, madam.
Lordship, may I
Then
submit,
here,
Lordship?
item 2 to 10, Awaited, You are for here, item 2.
Yes.
Respondent number 2.
Respondent number 2 only.
Yes, madam, you here?
My
my
apologies,
Lordship.
Your Lordship. I'm not aware of item 22,
Okay.
Your Lordship.
Lordship,
So
may
we're
I submit,
listening-
Lordship, in all the
Well,
three
listen-
matters, Lordship.
We're listing it after 4 weeks. Because
Your Lordship, a date, I'll humbly pray for date may be fixed, Lordship. 29th of July.
then list this matter on 29. As prayed for by the
Lordship,
learned
yeah.
D. Ghosh learned council for the list this matter on 29. Yes,
Lordship, in all the three matters, Lordship, interim order is there. Interim order may be continued, Lordship, in all the three matters.
This is the whole problem. Anyway, interim order. keep this.
In all the three matters, Lordship. Deeply obliged, Lordship. Deeply obliged.
Where's the disobedience?
Yes.
What is the order?
Order, my lord, will find it page number 13, the 11 directions. Paragraph 10. May I read, Lord? The
Shall
complete,
take a decision to release the pension to the within after period 2 months from the receipt of the certified copy of this order. Yes,
my lord, by separate forwarding letters, the certified copies of the order were submitted before the respondent authority.
or Mr. R.L. Tungan, Learned Counsel for the petitioner by the decision application under section 11 and 12 of the Contempt of Courts Act 1971, read with Article 2215 of the Constitution of India and Rule 3 of the Contempt of Courts within bracket Guwahati High Court Rules 1971, alleging willful and deliberate disobedience of the order of this court dated 04/04/2025, passed in WPC number 600 of 2024. Issue notice returnable by 4 weeks. Mr. Learned Counsel for the petitions to take steps for service of notice upon respondent number 1, 2, and 3 by Mr. for so and so within 2 days.
Much of it.
This case, my power has been divested, boss.
Huh?
My power has been divested. That is the issue. Official function.
Yes.
In this case, this is a notification. It's a role of technical assistant. There is a gazetting notification 16 April 2015, in which in support of that, I have an appointment. My appointment is at page number 20, annexure 2. The PTA has been appointed as a nodal officer for preparing public finance management system. This is the issue here, core issue.
Yes, any instruction?
Lordship, from the DPDO, Kurumkume, I have no instruction, but Lordship, the Deputy Director from Ethan Lordship have told me, and they have given me this document saying that they go by this document. They are saying that
Same.
the DPDO have, yes, he doesn't have any power to divest.
Is it?
This is not so. But then from the DPDO, I am yet to receive any. The impugn order is passed by.
Or to
DPDO.
transfer and posting Mr. Panchayat Raj Department.
They are saying that is their stand.
Have you been transferred?
Kindly see page 20, Lordship. Page 20 of my writ petition. It is clear that I'm a PTA and PTA has been appointed as a nodal officer, in which my name is at serial number 6. Kindly see, this is the following PTS. Order dated 17 April 2018.
Nodal officer.
PTA has been appointed as a nodal officer of this PFMS scheme. There is a division, Lordship. In Kurumkume, this is one is third Colorian, my place is another. His place is private respondent area, is a field of work is at Panishan, 10 Panishan. There is a division and Private respondent.
Where is the impugn order?
Kindly see, impugn order is lordship, page number 22, annexure 4.
50?
Yes. Lordship, 22. Page 22.
Ah, this is by the director.
No, Lordship, there must be something wrong. Page number 22, kindly see.
Huh?
Order dated 6 May 2025.
District Panchayat Development. Okay.
Yes, order dated in which my power has been divested, Lordship. In my WP, page number 22, annexure 4.
Not Mr. T. Tapak, learned counsel for the petitioner. Page 22.
Page 22, annexure 4.
Challenge made in this petition is to the order dated 06/05/2025 issued by the District Panchayat Development Officer, Kurumkume District, Koleriam, whereby the respondent number
Respondent number, it is
one
no,
whereby one Sri Chera Tapun. Respondent number
respondent number 6, Sera Tapung.
respondent number 6
Chera Tapung.
Chera Tapun, respondent number 6, who is working as PTA within bracket JE bracket close 10 Panisiam, page 22, huh?
Yes.
Paniasam ZP constituency is attached in the office of the is attached in the office of the district panchayat development officer, and the private respondent and the petitioner is directed to hand over all the charges of DNO within bracket PFMS bracket close Panchayati Raj under Kume district to Shri Chera Tapu, the respondent number 6. No, before that, huh? Attached in the office, not that has been directed to look up the charges of district nodal officer within bracket PFMS bracket club Panchayat Raj Department. In addition to these normal duties, and the petitioner has been is directed to hand over all the charges of DNO, district nodal officer PFMS Panchayat to the petitioner, to the respondent number 6. Mr. Titapak learned concept while placing the copy of the order dated 16/07/004/2015 regarding working arrangement of the engineers under Panchayati Rural Engineering Wing of Panchayat Raj Department submits that the impugn order clearly reflects the divesting of power of the petitioner
Power and function.
by the district Panchayati Raj. What is district?
District Panchayat Development Officer.
District
Panchayat
Panchayat Development Officer who is not a competent authority to pass such orders by transferring the power and functions of the petitioner. Mr. Issue notice returnable by 4 weeks as MSG at Learned Additional Senior Government Advocate enters appearance and accept notice on behalf of
1 to
others.
5 proceed.
Or 1 to 5, no formal notice no formal notice is need to be served, however, extra copies be signed, sir. Then counsel for the Minister for service and notice apparatus for 6, barrister question.
Interim order, Lordship. That may be passed.
Huh?
Interim order may be passed, Lordship. Because, Lordship, I have made out the case, Lordship.
Hard on interim prayer. Having considered the notification and no order dated 16/04/2015 and the memorandum dated 17/10/2024 issued by the Commissioner within bracket PR Government of Arunachal Pradesh and the Director within bracket PR Government of Arunachal Pradesh with regard to the pertaining to the working arrangement of the engineers under Panchayati Rural Engineering Wing of Panchayati Raj Department. It's here. And this, come on. It appears that the district Panchayat Development Officer
Yes.
Yes,
District Panchayat Development.
is not the competent authority to pass the impugn order, either transferring and assigning the duties and responsibilities to the staff of Panchayati Raj, including the employees working as, what do you call it, working as PTA within bracket J bracket clause, in the interim. It is provided that till determinable that the impugn order dated 6/05/2025 shall not be given effect to.
May I please?
Yes.
On the last occasion, your lordship given the directions to the council for the state to obtain instructions from the concerned deputy commissioner. This is a case of non-publication of my names in the official gazette, madam. The other, the respondents have nothing to do with my case. Only publications of the names in the official gazette is my petitioner's right, madam, my right. So only following on.
When yet to receive this instruction?
Yes.
Because 14 and 15 were holidays. Only yesterday only I could communicate. And yet to get instruction.
One day is also a big.
Hardly I had a talk with ESE. He's saying this is not in the
It's
schedule.
enough time.
This is not in the schedule. I spoke to ESE.
Madam,
We taken tomorrow.
Will issue notice in that case and will pending shall not be barred to.
for instruction tomorrow, madam.
I know he'll not.
This is not there.
Other is, the issue is very.
Then next week, so that we can. Is there private respondent?
No, madam. No private.
No.
Madam, this is nothing to do with the other case, madam. That the keeping the matter
No,
of
they said because of the complaint. Wait, order?
My lord, impugn order, my lord, that issue may be kept open, my lord, by, my lord, publication, my lord, allow me to publish the names in the official gazette, maybe, my lord.
No, and then we'll grant, Friday, we'll take it up on Friday.
My lord,
Six.
Annex
Or
six.
Mr. M. Kato, Learned Counsel for the petitioner. Mr. N. Long, Learned Counsel for the Learned Senior Government Advocate is granted further time to obtain instruction as directed by this court on 13/06/2025.
Fine.
List the matter on Friday.
Monday.
Friday or Monday?
Friday, my lord. Subject to.
Can it be on Monday so that he can
Yes.
obtain the instruction and Saturday, Sunday,
Monday,
Saturdays and Sunday he can
Yes.
go through
Monday.
the instruction, whatever he would like to. Monday.
My lord, my submission is, my lord, kept the, my lord, if there is a complaint, that matter may be kept, my lord, often for the parties, my lord.
But in that case, if there is a reason, wrongly or rightly, you have to make the complaint in the
Well,
part.
otherwise, that even if there is a
Because
complaint,
they may be saying that it should not be published. So in that case, you have to
my lord,
make them a
therefore, my lord, my
party.
submission
The
is, my lord,
complainant,
clear.
you think about it. All right?
There is likely to be this law and order problem.
Huh?
Law and order problem will be there.
Publication of names will not just cause, that is only. On Monday, man.
May I please, my lord?
Yes.
My lord, this matter pertaining to tender, my lord.
Hmm.
The notice inviting tender was invited by the Department of Rural Development, my lord, Papampara district.
Well,
UP.
this item 4 and 8, my lord. These are connected matter. Challenging the same impugn order, my lord. So just I requested my brother, like, if I can argue, because he is for the L1, I am for the L2.
Why you depriving him his privilege?
No, my lord, just we have come to a consensus.
We'll hear you also. Let me hear him first.
No, that's fine, my lord, that because
No, we'll also hear you. Together, I mean, first let me hear him. Yes.
May I
Yes.
please, my lord? My lord, the Department of Rural Development has invited notice, e-tender.
Manrega.
Yes, under
MGN.
Manrega, my lord.
Ah.
This scheme under Manrega, my lord, financial year 25 to 26, my lord.
Hmm.
My lord, this notice is in page number 39, my lord. Notice may come to page number 39, my lord. So here, the amount, the cost of the tender was rupees 8 crore 68 lakhs.
It's okay. How you are aggrieved?
My lord, the aggrieved is that, my lord.
Your bid has been rejected.
No, my lord. My lord, the department has constituted 7-member committee for evaluation of the tender, my lord.
Yes.
Including ADC, UPA, my lord, Papampara district.
Yes.
So after evaluation of technical bid and financial bid, I was found as a L1, my lord, which is most eligible to be awarded the LOI, my lord, letter of intent, my lord. So thereafter, the
where it is?
My lord.
Where it is?
My lord, this is page number 70, 75, starting from 76, my lord.
Where it is? Where
My lord, page number 76 is a
L1.
minute of tender committee, my lord.
Yes, which page?
My lord, page number
We find
70.
that you are L1.
70.
82.
It is in
82.
Technical
Eka Enterprise.
Yes, my lord. 82, my lord.
Page 82. Yes.
82.
Then
So 81 is, my lord, the operative portion, my lord. May I read out the operative portion? 81, my lord. Page number 81, my lord. Just down below, my lord. Therefore, in view of the above, the tender committee recommends awarding the tender to MS Ika Enterprise as L1 firm at their quoted rate being the most eligible and reasonable bidding firm based on the nearest to the justified rate as approved by the department.
yes.
And MS Rina Enterprise Construction, Rina Yangpo Construction as L2 firm and MS Brew Enterprise as L3 firm, respectively, for issue of tender, a letter of intent to the successor bidder for supply and procurement of material under Manrega for the financial year 25 to 26.
It's okay.
Yes.
Your
So,
name
my
has
lord,
been recommended.
Yes, my lord. So I was
Being
recommended
found to
about
be
the LOI.
L1.
Then, my lord, what happened? The department has kept pending for more than months, my lord.
Okay.
I was never been issued LOI, my lord. So later on 6/6/25, I was furnished document through RTI, and it has come to know that on 29, my lord, 29/5/2025, LOI has issued to the L3, my lord,
which was not recommended by the district authorities, my lord.
Yes.
The tender committee. So that was the difference being made to me, my lord. So in fact, my lord, I should,
This is
page number 85, my-
is the LOI
yes, my lord. So on what
to
basis?
L3.
See, he's a L3, my lord.
Yes.
So on what basis the department has taken these decisions? We have not known, my lord, so far. Even we seeking the clarifications from the concerned department, but they have not furnished any information.
Yeah.
Yes.
Let me please come to page 58.
Yes.
Yes, my lord, clause 14, my lord. Clause 14, my lord. Awarding of work order. Now, Roman 1, my lord. The tender shall be evaluated by the boards constituted by DC cum DPC at district level, my lord. Recommended at least 3 firms L1, L2, L3 to the competent authority for acceptance along with all relevant documents, my lord. 2, my lord. The joint director RE shall further scrutiny the tender documents recommended by the project director. The LOI will be issued to the L1 firm if the tender documents recommended by project director is up to the satisfaction of accepting authority. 3, my lord, the project director will issue supply order to the L1 firms on the basis of LOI issued by the accepting authority. Now clause 2, my lord. Now it says, my lord, the director, joint director RE has the authority to re-examine for further scrutiny of the tender documents, my lord.
So how can just do it behind their back?
Yes, my lord. My lord, please see page 82 now. 82.
Huh?
82. Last page of, sorry, page 82 of the writ petition, my lord.
Yes.
Serial number 3. This is the justified rate, 6.28.
It's okay. Why you are just behind the back?
I'm coming to it, Mala.
Yes.
I'm coming to that. 6.28%, Mala. This is the justified rate, Mala. Prepared by the department, Mala.
Yes.
Now, my lord.
Justified rate is
6.28, my lord.
28.
Yes, Mala. The
So
answer
I-
is here, my
yes,
lord. The answer is here itself, my lord. Now, my lord, this L1 and L2, my lord. Both are in, my lord, beyond the, my lord, justified rate, my lord. Now, this L3 is actually within the permissible limit, my lord.
L3.
Yes, actually, my lord. That is
L3.
that is the analysis of the directorate level. Yes, my lord. My lord, see, my lord, Eka Enterprise, my lord, minus 0.020%, my lord.
Where is the requirement of having this justified rate?
It
In
should
the-
be within, my lord, justified, it should be within 6.28%, my lord. It should be within 6.28%, my lord.
No, in the your terms and condition which you prepared, page 858.
Yes, my lord.
What is how the procedure has to be? What is the procedure of selection
Procedure, my lord.
or evaluation?
Evaluation, my lord, we have one SOP, my lord. This is the SOP of the department, my lord. So from 5678, my lord. The five, my lord, the project director shall constitute a board for opening of.
Is there any provision regarding this justified rate?
Justified rate, my lord. In the NIT, my lord. That, my lord, I have to take instruction, but my lord, what is the development, my lord?
May I
I want
please-
to submit, my
May I
lord.
please, my lord? My lord, even this,
Just wait, just wait.
Yes.
Let me understand first.
This is the order of evaluation, my lord.
How these justified rates are being worked out? Worked out. Worked out.
It is on the basis of market rate.
Market rate.
Yes.
Okay.
So last page, my lord.
Yes.
In the last page, my lord, of the
This.
instruction. Yes, my lord.
Yes.
So, my lord, here my recommended, my lord. MS Buru Enterprise quoted rate as justified rate, hence recommended for approval, my lord.
Yes.
MS Eka, he was designated as L1, my lord. And MS Eka Enterprise abnormal rate below the justified rate, my lord. MS Linear Construction abnormal rate below the justified rate, my lord.
My lord. Yes, my lord, even this L3, whom the district has, the district committee has recommended, even he was not qualified in the technical bid, my lord.
Who?
L3, my lord, who is the Guru interview, private respondent number 6 here in my lord.
Are you challenging his?
No, my lord, in fact, I'm just,
See,
no.
there is no doubt, so far as the quoted rate is concerned, you are L1. Page 58 provides that how it has to be awarded.
Yes.
3 questions, page 58. Come
Yes.
to page 58.
My lord, page 58, clause 2 is.
So they have done it as per the, and the SOPs, they have done it.
My lord,
Power has been given to these authorities. Only thing is that should be not be behind you. It should have been informed and you should have done it. Have you informed all these things?
No, no, my lord, we were not informed, my lord.
My lord, they submit the documents before the district board. District board makes the, my lord, the evaluation, my lord. After that, we cross-examine it, my lord. We further scrutiny it, my lord.
So it's clearly provided in the what do you call it?
SOP, my lord.
No, here. Tender, what do you call it?
Yes.
SBD.
This is SBD.
SBD. It's clearly provided.
My lord, here in clause 2, my lord, as my learned friends read out, my lord. Clause 3 is only stating about the
Special conditions.
scrutiny of document, my lord. So here, tender documents already scrutineed by the district committee, my
It's
lord.
all right. There's a provision, page 58.
So that was not.
How the work is to be awarded. Have you seen it?
Yes,
You
my
have
lord,
seen?
I have gone through, my lord. So
And
region
they
has
have
to,
furnished all these documents. By as per this, they have done it.
my lord, region has to be.
Yeah, are you saying that the without the justified rate working out of the justified rate cannot be implemented?
Yes.
Applied here.
My lord, justified rate has been
See,
provided.
simple. It's very simple. Even just because you are L1, it cannot
Yes.
be. There's a procedure prescribed.
But my lord, my lord, L1 was based on the justified rate being provided by the department. And based on that, district committee has recommended, my lord. So
It's okay. As per the quoted rate, admittedly, you are there's no dispute. You are L1, but the work has to be awarded on the basis of the justified rate.
Yes.
And they have worked it out. And which has been the project director, joint director, they have been empowered.
So, my lord, justified rate has been declared by the district authority committee, my lord.
It's not a district
So
authority.
after
Their
evaluation of-
recommendation, you see, tenders shall be evaluated by, they have evaluated who is L1, L2, L3.
Lordship, if we going through the finding and recommendation, my lord, it's page number 80, my lord. Finding and recommendation, my lord, from district authorities, my lord, district committee.
Yes.
May I read out, my lord, page number 80, my lord. Down below, my lord.
You have read it?
Finding
80,
and recommendation.
80.
Yes, my lord, page number 80, down below, my lord.
After thorough evaluation,
After thorough evaluation of the financial bid of the above mentioned, technically qualified bidders based on the department justified amount approved by the technical accepting authority for rupees 8 crore 13 lakhs 92.3 92,311, that is below 2.62% of the BOQ amount. The committee found that MS ICABRA's quoted rate quoted rupees 8 crore 13 lakhs 75,750, which is the nearest to the departmental justified amount within the acceptable limits, with variation of below 0.020% of justified rate. And MS Rinia Yangpo Construction, which is the second nearest to the departmental justified amount, rupees showing so, my lord, and variation of below 0.168% of justified rate, my lord. And my lord, MS Buru Enterprise, which is the third nearest to the departmental justified amount, rupees 8 crore 16 lakhs 35,427, which is variation of above 0.298%, my lord. So committee has clearly stated in their finding, my lord, and recommendation, my lord.
What is this?
We are very much on the justified rate, my lord. And here committee has never been stated that I'm going below this abnormal rate, my lord.
6.28.
Yes, my lord. Clearly, my lord, it is said that justified rate is 6.28% as per BOQ, my lord. So based on that, I am the nearest farm which was quoted the rate, my lord. Seven-member committee has decided, my lord, in fact. So if there was any.
Yes, my lord. Again, back to you, my lord. Justified rate is 6.28.
Yes.
Nearest is the petitioner.
Yes.
Nearest one.
How can you change it?
What we are saying, my lord, it has to
You are
be-
also admitting that justified rate is 6.28.
Yes, my lord.
Then
Yes, ma'am. So it should be within 6.28,
huh.
not below 6.28, ma'am. Since they are in the minus, my lord, below 6.28, my lord. Otherwise, my lord, we could have accepted the bid of minus 10% also, my lord. So we are accepting which are within, my lord, 6.28, my lord. Since they are, my lord, beyond 6.28, my lord. So why we have not accepted them?
Why this third nearest is within?
Yes, my lord.
How?
Plus 0. My lord, page 82, my lord.
Huh.
Buru Enterprise, above plus 0.298%.
Huh.
That
This
is
is
why, my lord.
plus or minus?
Third nearest
my
is
lord.
plus, my lord.
Huh?
Plus 0.98%, my lord. Serial number 6, my lord, first, my lord. Buru Enterprise. L3, my lord, has been, my lord, they have quoted 0.298%, my lord. So it should be within the justified rate, not beyond the justified rate. Since both the L1 and L2 were beyond the justified rate, my lord, their bids were rejected.
So according to this, lowest one is the L3 is
L1.
within justified rate.
Yes, within justified rate. Yes.
Show us something. How?
My lord, that is the workout carried out, my lord, that I have submitted, my lord.
No, that is you have simply one order, one line, two line order.
Yes.
As per superintendent engineering wing of the director, scrutinized standard document headed by Janda along with his note. As per section 2, para 2. The details comparative statement both in physical and financial have been worked out. Annexed A for each study block and the ground of rejection for respective pay who do not as per justified rate are specifically mentioned on the other hand, we found vendors who have qualified. So in the district level, you have a different method of working out the justified rate.
My lord,
In director level, you have a
my lord, we are there to scrutiny whether they are correct or, my lord, right or wrong, my lord. We are only for there, only for that purpose only.
So therefore, the
We found, my
tender
lord, it is wrong.
committee who has recommended it
Yes.
was not correct.
Yes, my lord.
It was not L1 is not this thing petitioner.
Yes, my lord.
According to L1 is the
L3, my lord.
third.
Yes, my lord.
L3.
Yes, my lord. Because it should, as per the NIT, my lord, it should have been within, my lord,
My lord,
justified rate.
if the authorities, if they don't want to award the work to L1, my lord, so L2 may be awarded because if they have stating about the abnormal rates.
What he's saying now is that since the power has been, since the director level, in the director level, joint director or something, they have been empowered to scrutiny.
That is there, my
And
lord.
when on scrutiny, you just share with him.
That is
They have given
my lord,
guarantees
they
annexed
have
law.
not furnished any justified rate. So as per the committee,
It's
based on-
clearly
In 7 April 2025, my lord.
as per
based
section
on-
20, so and so details of comparative statement both in physical and financial have been worked out and annexure A for each CD block, Balijan, so on, Kimin and Sagal, the ground of rejection. So the detail is said. Where is the annexure? These are annexure A.
Yes, my lord.
Or also in 7 April
So my
2025,
lord, my prayer is that
justified rate is hereby
department
approved as
authorities will come with
6.28.
the affidavit, my lord, and then till then, my lord, a letter of intent may be stated, my lord. That is my humble prayer, my lord.
Don't move the figure.
Even, my lord, we were seeking many times in regards to decision being made by the authorities, my lord, but they have denied
I
the
think
punishment.
they will file, allow them to file response.
My lord, mostly, my
So,
lord, may please come to page 15 of the writ petition.
Huh.
Whether he can file a writ petition also, my lord.
What?
That is the vision. My lord, his registration has expired, my lord.
Huh?
My lord, page 15, my lord. His registration, my lord. It is the registration 20 June 2017, my lord. Now, my lord, may come to page 16, my lord. It is valid for 5 years, my lord. Now, my lord, 5 years has left, my lord.
Where is it? Where is it?
It's serial number 9, my lord. Page 16. The enlistment notified in this order is valid for an initial period of 5 years from the date of issue of this order, my lord. Now, this was issued on 20 June 2017, my lord. Now, 5 years left on 2022.
We have already renewed, my lord. We have already renewed. So this is my mistakenly placed the old one, my lord. We have already renewed, my lord.
Not Mr. Yes, Mr. Tara. You are L2.
Yeah, well, that's why I was trying to justify.
Why
that.
he's saying that if he's not given, he should be given to L2.
No,
Who you are to say that?
My lord, as per decision being taken by.
How you are authorized to say that? There's a collision.
No.
Well, it may not be.
Then?
But my lord, I can nullify his argument if
Ah.
I am allowed to argue item 8 together because same cause of action is there. So, Samna. Now, my lord will kindly come to have my read petition item 8. I just placed a document.
So I'll
Everything.
I'll issue notice in this case first. And
First,
I'll
yes.
hear you. Huh?
Yes,
Heard Mr. N. Rama, huh?
Yes, ma'am.
Learned counsel for the petitioner. Agreed by the rejection of the bid of the petitioner in respect of the pertains to what is this supply of material under MG and Rega RG 2025-2026 in respect of Balijan CD block within package Roman 1 package close pursuant to the tender NIT dated NIET notice inviting e-tender dated 31/03/2025 by the Department of Rural Development, Government of Arunachal Pradesh, and the consequential issuance of LOI. What is the LOI?
Letter of intent, my lord.
Where it is? No,
My lord,
where it
It
is?
is in page number 85, my lord.
That
29
LOI
May 25.
issued LOI dated 29/05/2025 issued to respondent number
My lord, 6.
issued to one MS Buru Enterprises. Come on, respondent number 6 here. Come on. The present petition has been instituted. Is instituted on the ground that the petitioner by the what do we call tender committee,
District level.
the district level tender committee, after due evaluation of the tender of the bidders has recommended the petitioner having been being the L1 form Mr. Issue notice to the respondents as Mr. B. Pitcher, Learned Counsel, Learned Standing Counsel for Rural Development Department, enters appearance on behalf of respondent number. All the respondent.
1 to 5, yes.
1 to 5. No formal notice may be sent. However, extra copy so and so. And petitioners to take steps for service of notice upon respondent number 6 by register for so and so. We'll see.
My lord, till final, return, my lord, letter of intent may be stated.
The award of contract.
My lord.
Contract.
Yes, my lord. Award of contract may be stayed, my lord. Otherwise, this is supply of materials, my lord. If they will execute the agreement, so
shall be subject to outcome of the petition.
my lord, till returnable that, my lord, letter of intent may be stayed, my lord.
It's 29. Now today we're
my lord, till 10th of June, we seeking the documents.
We'll
seeking
consider in the
result of the
you file the affidavit within a week.
Yes, my lord.
Within a week.
Yes.
Within a week.
Within 2, because there are so many cases filing for this MG Narega cases, my lord.
What can we do? We cannot stop them.
My lord.
Because we're not pressing and staying there.
my lord, this is supply of materials, my lord. If they will execute, they will agreement with the department, definitely they will supply the material. So the matter may be in practice, my lord, become. So
No,
my lord, till next returnable, my lord.
Supply of
So
material.
you file it within 1 week. We'll consider.
My lord.
My lord, till then LOI may be stayed, my lord.
Supply of materials, my lord. The ultimate, my lord, here the sufferer would be the village, my lord, people.
Village people.
My lord,
Yes,
this is
my lord.
MG Narega. So now this is,
MG Narega only for village people.
in fact, this is. My lord,
You
if-
file within 1 week,
Yes.
we'll consider, we'll
My lord.
dispose of the matter.
My lord. God bless you.
my lord.
Wait, please.
Yes.
It's a case, my lord, the lordship will see that every attempt was been made to, my lord, favor the private respondent. My lord knows the NIT was dated 11th,
You are L1, L2.
L2.
Yes.
My lord, kindly note that the justified rate in respect of Dumpodojo is minus 8.05. NIT was dated 11th of June, then your lordship will kindly have the SBD at annexure 4, page 50.
Page 50.
Yes. This is
Yes.
the SBD, page 64 is the special conditions of contract that my learned friend was earlier reading of. Page 64. Then your lordship will have, this is the special conditions of contract. Your lordship will have page 66. Awarding of work order that my learned friend was reading of. The tender shall be evaluated by a board constituted by the DC cum DPC at district level and recommend at least 3 firms to competent authority for acceptance with all relevant documents. Purpose it appears is they will scrutiny and recommend 3 firms. They will not recommend that this firm should be given or this firm should be given. They will only recommend 3 firms along with relevant documents. Then the joint director Ali shall further scrutiny the tender documents recommended by the project director. The LOI will be issued to L1 firm if the tender document recommended is up to the satisfaction of the acceptance authorities. So the mandate is that the joint director shall further scrutinize, which has not been done in this case. That is why I'm pointing this out. Sir, he has to do it. Now at page 67 are the additional conditions of contract.
Yes.
Your lordship will have page 68, 25, clause 25. How they are supposed to go about it.
68.
68. Acceptance of tender shall be based on SOP number 4/1 and 1125. That is the clause. And 5.19 as per CPW manual and SOP 554 work manual 2022. That is CPW manual 2022. I will kindly note this SOP number 4/1/1125. 1125 is a clause. Your lordship will kindly have SOP 41 at page 145. This is the extract from the CPW manual. SOP number 41. Your lordship will kindly have, your lordship will recall 1125. 11 is at page 148. Processing of e-tenders. The SBD says this will have to be followed. 11 at page 148. Then your lordship will have 1125 at 150. Variation up to 5% over the justified rates is ignored. Over the justified rates, not the estimated cost. Over the justified rate. The justified rate in this case is minus 8.05. Variation up to 5% over the justified rate is ignored. Variation up to 10% is allowed for peculiar situations and in special circumstances. I am not bothered with this. 5% is ignored over the justified rates. Now, your lordship, mine was 8.55. This could not have been taken into account. It is not supposed to be within the justified rate.
Variation up to
Yes.
5% over the justified rates is ignored.
Ignored.
So if it is
8.5,
variation
8.5, yes.
Variation of
Variation
5%.
of 8 after 8.5, 5% has to be ignored.
So what would be the?
It would go to 13.05. Minus 13.05. It is as per the tender document.
So yours is?
Justified is 8.05 minus 8.055. 0.5. Not only that, my lord will see what they have done. At page 155. This is an online tender.
Yes.
PG construction, I have quoted an amount of 9,38,19243,845. This is auto-generated, my lord will kindly note this. It is the exact figure that the bidder's code that comes out from the auto-generated portal. KK Enterprises serial number 3. 938,19964.224. Auto-generate says he is L3. May I kindly note these figures because they have manipulated it. So that this figure, my lord, that quoted by Messrs. KK Enterprises, this also goes beyond 8.05. It goes to minus 8053. That could not have been a reason for rejection. There is all another thing, but that is the reason they have given. It goes to beyond the variation justified rate. So next page is the minutes of the technical bits. Everybody has been qualified. At page 157, you also will kindly have a look. This is again the auto-generated item rate, schedule of works. My lord will see the first one is the petitioner. Second one is the KK Enterprise, the private respondent. Here also your lordship will see total figures at the second page, 158. Same figures as the BOQ summary. This is also auto-generated. 9381996.4.22. These are the auto-generated figures. Then your lordship will have the minutes at page 159. One, Messrs. KK Enterprises has quoted a bid price of rupees 9.3829. It was 19 earlier.
10,000 lower than this. If it was 10,000 lower, it goes beyond the justified rate. That is why this has been done. Two auto-generated says it is 293819. In the financial minutes, they say it is 29.
29.
Yes.
Where is that?
Your lordship will
Page.
have the auto-generated one. First one is at page 155, serial number 3. In place of 29, it is 19. The purpose is, if this remains, it also goes beyond the justified rate.
Auto-generated
BOQ summary.
BOQ
This
summary
comes out from the
is-
portal.
Hmm?
Yes. E-portal.
KK Enterprise.
Yes. 93819964. It is 19. Only 700 rupees difference between me and him.
938. Nine three eight two nine.
Yes, 29. They have raised 10,000. So that it goes.
It is 19.
Yes.
Where is auto-generated 19?
19. Both the documents. It's page 157 also. 58 also.
Yes.
Yes. So thereafter, my lord knows we filed this writ petition earlier.
Yours is PG
Ma-
Enterprise.
I am PG, my lord. Mine is 9381924.85.
It is correct.
That's correct.
Hmm.
It is correct. Only he has changed.
Aarti is also correct.
Everything.
Only this.
Only
in
K.
respect of
Yes,
KK.
Yes, yes.
They have increased.
Yes. Your lordship will have page 175 first.
75.
These are the documents that my learned friend furnished on the last occasion.
Hmm.
What they are trying to say.
Hmm.
This is the reason they say.
Hmm.
So they have uploaded it. The financial bid was opened on 015-2025 at 10,000 hours and was evaluated. Messrs. KK Enterprises quoted a bid price of 938. It is 29. Now it comes to 29.
Otherwise, it is 19.
19. If it is 19, it goes beyond minus 0.53.
Which is the is more than
Just beyond the
more than the 5%.
Yes.
Yours falls under.
No, mine also goes beyond 8.55.
Okay.
But my case is, in terms of the SBD, 5% has to be ignored. I'm only 0.5. So they had that misunderstanding in their haste to, my lord.
But it's more than 5%.
Yes.
Up to 5%
Yes.
of the justified that can be ignored.
Ignored. Yes.
Yours is admittedly beyond 5%.
No, within.
Within. What about this respondent, KK?
KK also.
Within 5%.
Yes. As far as the manipulated rate, yes.
Otherwise,
also within 5%.
you or this other one?
Otherwise,
Aarti,
also
what is Aarti?
all are within 5%.
Within?
Yes.
So how they select it out of the three?
That is why, my lord, their own standard document, most probably they did not read it properly. So that this KK Enterprises comes within minus 8.05, they firstly manipulate the amount so that his comes to 8.044. Now 8.55 has to be ignored in terms of their own bid documents. So the ground on which my bid has been rejected, that it comes beyond the justified rate of minus 8.05 is not a ground at all, because it is their own document. And secondly, it is on the basis of this recommendation. The recommendation LO has been issued in respect of the private respondent. It is a mandate of the SBD that the joint director RE has to re-scrutinize it. That has also not been done.
This is by whom?
This is by the committee headed by the project director. This is in 1st of May.
175.
Yes.
On the basis of this only, this
Yes,
has been-
yes. There's your civil fine from 168.
Yes.
My lord, actually, they
It's
rushed,
apparent.
May 7. Actually, they rushed for withdrawing their writ petition, my lord. Actually,
okay.
I was with my original records, my lord. They could have, my lord. There are so many things, my lord.
What?
They went by my this instruction,
We'll not go into anything.
Yes,
You
ma'am.
just simply tell us
my lord.
why this page, auto-generated page 155 and 175. Why is the difference?
125, my lord.
In respect of KK Enterprise. 938199,
125, my lord.
page 155.
155.
This BOQ
Yes.
summary.
Page 175, my lord.
Yes. You just note down 938199964.
Yes.
And then come to 175.
For that, I have to see the original bit.
You, in place of one, you have shown it two.
And this was brought to the notice of them at page 160. To file the representation regarding discrepancy in the rates.
There must be some mistake, my lord. In the original, my lord, we have done the scrutiny in the
That's why he's challenging. Not only mistake.
No, this is of the district board, my lord. We have the state board also, my lord. State board, my lord. This is the original documents. It's not manufactured now.
No, you justify this. This is auto-generated. And this is district board. Where is the decision?
Decision, my lord. My lord, I have flagged, my lord.
Yeah, just give the relevant one.
Yes, my lord. I have- From Dumpurijo CD block, my lord.
KK Enterprise. PG construction is
PG is the petition, my lord.
938192243.
Yes, correct.
243.84.
Yes.
Fine.
Then KK 9381999
Yes.
64.22.
Yes, there is the BOQ auto-generated one.
Yes.
9, my
That is correct, auto-generated one.
38, my lord.
19
Yes.
19964.22.
Yeah.
Not
Yes.
one.
Yes.
938. Yes, as per the evolution of the headquarter level, my lord, was found that this private restaurant.
What is this? This is by whom?
By the headquarters.
Headquarter.
Yes. This was by
This
the
is
district headquarters.
four member.
Yes, my lord.
Assistant Project Officer, Joint Director, Assistant Project Officer, Extension Officer. They have given it correctly.
Whatever it is, if that is so, then his bid also goes beyond minus 8.53. Mine was rejected on the ground that it is beyond 8.05, being 8.055. Then, my lord, same thing. And my bid is lower. If you are going beyond the, if you are recommending beyond the justified rate, why not the lower then? Because my bid is apparently 700 lower. Please also, my lord, kindly have a look at the file notings for a moment again. At page 168.
Just wait. Rate quoted below justified. Justified rate. Hence recommended for approval. Why is the ground?
My lord, it is simply written, my lord, it is below the justified rate of the British company. Yes.
His also is 8.53.
Mine, of the private restaurant, 8.04, my lord.
No. That would be 8.04. That is why I am saying, my lord, will kindly have page 168. 8.44 will be in respect of that amount, 29 amount. Serial number 2.
168.
68. Serial number 3, KK. L3. 93829. This is 8.04. 19 is 8.53. We have calculated. It's 8.04. This is their own document, my lord.
Just wait.
This document, which does not tally with the document produced by my learned friend that my lord was reading out, there was 19. 19 is not 8.04. 29 is 8.04. Be them on is 93829. Not the 191. Quoted rate 8.04.
No, here also KK is shown as 93829.
Yes, 29. And the record paper learned friend is produced and the auto generated that tallies. That is 19. 19 is 8.53. 8.04 is in respect of the amount that does not tally with the record of the learned friend is produced. It is the enhanced one.
So if you go by this 29,
yes.
If you add 10,000, it comes to an
8.04.
8.04.
Yes.
And if it is 9829, it comes to?
If it is 19, not 29, it comes to 8.53. Same thing.
Both of them?
Yes.
No, yours is 8.85 and his is.
This is the manufactured amount, my lord. If your lordship kindly have the auto generated and the record that my learned friend has started.
Auto generated are, my lord, filled by the authorities itself. There might be some mistake, but my lord,
that is
what I
19.
said-
Just a minute. That is 19. My lord was reading out 19. I remember. KK. Not 29. 19. My lord was reading out.
19.
If it is 19, it goes to minus 8.53. This 8.04 is in respect of the amount where 10,000 is increased. This is their own document, page 168.
See, 93819.
Yes.
Up to it's same, but yours is then next 243.
Yes.
0.84.
Yes.
And KK is 964.22.
Yes.
So there will be difference. It cannot be same.
700 rupees.
Whatever.
Mine is minus 0.55, 8.055. His is 8.053. Mine is lower. In any case, 0.5% has to be ignored. So mine is lower.
Very difficult. There's a
My lord,
judgment
my
of
lord
this
will
court
kindly see
on
this
the
8.4.
variation.
8.4.
There's a judgment on the variation, 5% variation.
5%.
By Justice Mehdi.
Yes, I'm aware. I was there.
Huh?
Yes, I was there.
Yeah.
Yes. But the issue.
Do you have that?
Oh, I have not brought it. I can bring it at 2.
But what I say, my lord, we are not
We'll
required.
examine it, but no entry.
My lord will kindly say the confusion here is it is not 8.4.
We'll simply say that subject to outcome.
Subject to outcome, my lord, supply matter, everything goes.
No,
I have prima facie showed, my lord.
He has the documents. Let them file within a week.
Yes, my lord, the document itself shows.
Dispose them.
The document itself shows.
No, it's okay. Now the final authority,
Yes.
the in the director level, yours is shown the same exact figure, correct
Yes,
figure.
yes.
So
no, my lord.
According to let me, let us deliver on this. Privacy, yours, you have quoted the last three figures, 5 figures, and ignore just this thing, point also. 243, and his KK is 964.
Yes. 1919, 700 rupees difference. So we will not go by this, say manipulated now. If we go by their records, so mine is 700 rupees lower.
Yours is lower.
Yes. The justified rate is minus 8.05. I have been rejected because on the ground there.
So yours is
minus 8.055.
0.55.
Yes.
And
his is minus 8.053. Mine is lower by 0.2%.
0.53.
Yes.
Yes.
The justified rate is minus 8.05.
Okay.
I have been rejected because I am beyond the justified rate of minus 8.05. Then how can his be, my lord, allowed? That is the simple thing actually here. The records are here now. The manipulation was done in their misunderstanding that it has to be within the justified rate. So they manipulated it to bring him within 8.4. So we'll forget about it now, my lord. Since the records are here, his also is minus 8.53. Let them file it, my lord. Let it be stayed, my lord. The work order has not been issued.
For what my lord, I have provided that, yes.
Within a week, my lord, it's the same thing, my lord. But at least some protection, I have prima facie showed, my lord. And beyond 5 has to be ignored. Justified 8.05. His is also 5.3. I am lower. If you are ignoring the justified rate, why you are not giving it to me? And it has to be ignored in terms of the SBD itself.
Otherwise, my lord, without entering into the merit of the case, my lord, a person has filed a writ petition without any authorization, my lord.
No, we'll go.
What authorization?
After
The
hearing
petitioner is here.
this much will not go.
Well,
Anyway,
Locum brothers, my lord.
We'll see it too.
Yes. Yes. I will clarify, man. We will not even go now for the 8.B minus 8.053. That also goes beyond 8.05. The justified amount. This 8.00044 is in respect to the enhanced amount. This is in the record itself. The one that comes within the justified. In any case, my lord has seen 5% beyond, my lord, has to be accepted, has to be ignored. So this is it. 8.44, clearly they have reflected the other number.
in the file noting and the bid evaluation report.
But finally, the joint director, scrutiny by the joint director has given the correct figure.
Yes. So, but the percentage is wrong. Percentage would be 5, then minus 8.53 then. The 844 on the basis of his recommendation is met is in respect of the other figure. So that's why what I'm submitting now is, even if we forget the enhanced figure, then his percentage is also beyond the justified rate. So it is on that ground my bid was rejected. So he's also ought to be rejected then, my lord. Apparently, my lord, just to favor him, this is being done.
So which one is lower? 0.53 or 0.55?
55.
Because it's a minus.
Yes. If your lordship have page 175 and the file noting, it will be clear. The 8.44 is in respect of this figure.
No, we'll take it by the scrutiny by the joint director.
Yes. So it would be 8.53.
Then according to you, it's higher.
Yes, it is higher. And beyond the justified rate also. The very ground on which my bid was rejected.
Yes,
then,
my lord. What I am submitting, my lord, we do not require to enter into the merit of the case, my lord. My lord,
we have already entered.
My lord, my lord, please kindly come to page 43, my lord.
Let us do one thing. You file your affidavit, we'll consider after a week, we'll dispose of it. Since they have already issued the LOI.
No, my lord, they are supposed, the project director is required to issue the supply order.
Agreement is also there. So we'll after 1 week.
Yes,
we'll make it clear that it is subject to outcome.
Subject to outcome.
And if they don't file, my lord, by then?
We'll dispose of the matter.
My lord, will record that. Otherwise, it's
because
crystal clear, my lord.
This is basically a technical thing.
Yes.
So,
but record is
Honorable Supreme Court says courts are not expertise in this.
No,
matter.
my lord. I can
These are
show
all
from
these
the record.
technical thing.
The percentage of 8.44 has been in respect of the other figure. You will also kindly pay 175.
Yes,
for a
yes,
comment.
absolutely. Yes.
Then, my lord, it's apparent.
So minus 8.055 is lower than the higher than the
lower
than the minus 8.053.
Yes.
Okay.
Yeah.
Okay.
And the justified rate is minus 8.05. My bid has been rejected because it goes beyond 8.05. So his also goes beyond that.
Yes, what do you say on that?
That is it.
My lord,
now we'll not go into whether they have increased or
Yes.
I mean
Yes,
enhanced or not.
The
Let us
record,
go by your
what
record.
he has produced.
Your record that is by the scrutiny by the evaluation done by the joint director.
Yes, ma'am.
So it's a same the quoted rate by the bidders, right?
Yes, ma'am.
Now it's say this. If we go by this,
my lord, how far we
KK is 8.053, and petitioner minus 0.055. It is both are beyond the the justified rate.
Yes, both.
So what is the how do you, I mean?
It would be the best, one of the authority would be better person, the engineer, the expert in this field, my lord, because we are not expert in this
has
field.
to be expert certain norms and the procedure.
My lord. We will file our affidavit, my lord.
My lord will kindly note the difference is only 700. Mine is minus 8.055. 700, so 8.05. And that is what I have been harping along all along. The 8.44 figure
No,
in respect of
according to
829.
Since yours is higher.
Yes.
All right.
Lower.
Therefore, as per the variation, your case should be considered.
Yes. And my lord will see why my bid was rejected. It is because it is beyond minus 8.05.
It is because minus 8.055.
Whereas the respondent number 6.
Is also minus 8.053. Beyond 85.
But then his justified rate is shown to be minus 8.044.
Yes.
That is incorrect.
Yes, my lord. That is the, my
That
lord,
is not correct.
that is the calculation of the authority. my
No,
lord.
that is wrong calculation. If that is the case,
That is in calculation in
on this basis only you have given.
the other amount, 8.44. As prima facie.
My lord, let us follow the notice may be issued. We will file our affidavit by a week.
No, we just cannot allow them. Will you file within a week?
My lord.
We'll dispose it of.
My lord.
Come in, even if you don't file, you bring, if you cannot file also, we'll dispose of the matter.
My lord.
Simply you have to clarify this.
Yes, my lord.
See, if the amount is taken as, higher, increasing by 10,000.
My lord.
It obviously, it comes at 0.844. 8.044.
My lord.
So
That is
it
within the
it should be given.
My lord.
But you have recorded the correct figure 19,
Yes.
not 29.
My lord.
So it comes at minus 0.05, 08,
My lord.
minus 8.053.
Yes.
Yes, my lord.
So
I have to, my lord, take instruction, my lord, because I am not expert in this field. But my lord,
nobody is expert.
My lord, since the supply order has not been issued, my lord may stay there, my lord.
No, the
no,
agreement
has been executed. My lord, the supply order has been
10th of June.
Yes.
This is a difficulty, my lord.
That's
This
the problem.
become influxes, my lord. And if
No,
I have shown prima facie, my lord.
No,
what they have-
within next week after we'll consider.
And in the event, my lord,
We'll say subject to outcome.
Yes.
And the
If you
maintainability also, my lord.
find that it is not justified and it's not.
Maintainability, I can argue right now.
My lord.
I can argue right now.
You raise your
Yes, we shall
maintainability.
the judgment, my lord.
Heard Mr. Deepang learned counsel to the petitioner. And also heard Mr. B.P. learned standing counsel for Rolling Building Defendants. You take Dusty also in that case.
This is the difficult. There's a private respondent. Next week, my lord, he
That's what
will.
I'm saying. You take Dusty.
They will do that.
For respondent number 1, 2, 3, 4, and
Five.
5.
6.
5 and 6. Agreed from the rejection of the bid of the petition and issuance of LOI to the respondent one respondent member. Issuance of LOI in favor of one MSKK enterprise. Respondent number 6 hearing, number 7 hearing. Pertains to the supply of material.
Yes.
Supply of material. Where is the NIT?
Page 48.
Supply of material under MGNREGA 2025-26 in respect of package to Dumporija CD block pursuant to the NIT dated 11/04/2025. The present petition has been instituted. Mr. Deepang learned counsel to the petition while referring to the documents referring to the scrutiny evaluation done by the Joint director.
Joint director, but I don't have money.
No, you don't have that.
No. And how he can do it, that also is not understanding.
No, no, refer to the
175, I'm referring.
uh,
Evaluation report,
175.
175. This is by the district level board.
Referring to the evaluation report of the financial bid by the district level board submits that the bid quoted by the rate quoted by the respondent number 6
7.
Respondent 7 is 93819,964.224, whereas bid quoted by the petitioner is 9381924.845, page 155. But the financial evaluation board has illegally increased the rate of the respondent number 5, rate quoted by respondent number 7 as rupees 9329964.2022 to 159. It's 159, right?
Yes, 175.
159 also it is shown as.
Oh, yes, 159 also it is shown. Yes. This is the minutes.
Which which is less than, which is less by minus 8.044% than the tender cost. By taking the justified rate at the rate of 8.05% below the BOQ amount, which is glaringly illegal, as the petition, the respondent number 7 has quoted so and so, which comes to 8 point, what is that? Minus
8.053.
Minus 8.053 as per the actual rate quoted by the respondent number 7, whereas petitioner has quoted so and so, which comes to minus 8.055. You take this also. Therefore, he submits that the issuance of LOI to the respondent 7 is clearly illegal and arbitrary. Issue notice to the respondent returnable within a week. As Mr. B. Teacher, London Standing Council appeared for state response number 126, no formal notice. However, is directed to file filed the affidavit in opposition on or before the next date. Learned counsel to the petitioner to take steps for service of notice upon respondent numbers 7 by Dusty Mott. Having considered the submissions and on perusal of the records annexed to the writ petition as well as produced by the learned standing counsel, it is provided that the award of contract to the award of contract issuance of LOI.
The issuance of supply order, my lord.
Issuance of supply order.
Yes, they issued it.
Issuance of supply order to the respondent shall be subject to outcome of this review.
I don't know, kindly see. This matter was decided on 13th. Part wise, they are producing the document. This is of 12th. I believe it.
One by
My lord,
One by one.
my lord, on that day, I was here, my lord, with the original records, but they withdrew, my lord. They withdrew the case, my lord. I was able to submit the entire document. That's why I
with the records again.
Yes.
Kindly will settle the matter.
Yes.
my lord.
It's apparent now what has happened. The records itself reveals. I hope it is not changed. Problem.
Yes, we'll complete the motion. Yes, sir. What is this?
Wait, Lordship. Lordship, this is a matter where the petitioner was promoted to the post of inspector in the year 2012. And after that, they have not been given promotion. And in the year 2025, in the month of April, a new rule came, and on the basis of that, the DPC is going to be constituted. These petitioners, as per the service rules, became eligible after completion of 5 years as the post of inspector. And the full post fell vacant in the year 2022 to 23. That is before the 2023 rules, amended rules come into force. So, in short, my humble prayer is that our case may be considered for promotion without considering the new service rule. Your Honor may see page 36.
Well, issue notice what's there.
Lordship, what happens? A new WT message has been issued.
Where it is?
It is at
Page 69.
145.
Yes, 145. 145.
Yes. Type page at 146. So by this proposal are called for Lordship, NOC from the housing department and their service particulars. So if this is not stated, then because the name of the petitioner number,
it's on the 10th of April.
no, Lordship, it is on 5 of June, 5/6/25.
That's what I'm saying. Page 144.
Page 140, 144. The next page,
145 is
see-
what?
Next page may see that is, I have typed it and it is 5/6/25. It is issued
Just
on-
furnished up to date NCR appearing in the last 5 years till March 2025. And also furnished property return of the last 5 years. It is requested to forward the above mentioned required document to PHP on or before 26/2025. Huh?
Yes, sir.
They're just seeking documents.
Okay.
Thereafter, that will be considered. It will take time.
But Lordship, if the DPC is held on the basis of this, then
See, we know at this stage, we don't know whether the posts were of 2022 before
Lordship,
completing.
I have that, Lordship. Your Lordship may see page 160.
You have been made ineligible
One
by new rule.
Yes, Lordship.
What's the first rule?
Is 2006 rule. was in force
So
at
the length of service,
5 years. It is at page 60.
5 years.
Yes, Lordship. It is at page
And
60.
new rule?
As per new rule, Lordship, length of service is okay.
Hmm.
But what happened? Some fractions are made. There are 3 wings of Arunachal Pradesh Police: civil wing, IRBN, and APPBN. Now, the promotion is to earlier it was a common cadre. The senior most personnel was supposed to get promotion. Now it has been made that this for the civil police there is more person to be accommodated for promotional post. For APPBN and IRBN lesser, there is some percentage on the basis of the number of posts held. Now my guess is that this new rule came into force after the post fell vacant. The period when the post fell vacant, the 2006 rule was applicable. So the promotion should be made on the basis of the 2006 rules, and we may be accommodated.
Not possible.
You also will see page 2006 rules.
No, have you been made ineligible? Then matter would have been different by the new rule. They have been streamlined, they have bifurcated, they have been streamlined, they have given.
As per the new rule, we shall not come into consideration, Lordship.
Huh?
As per the new rule, we shall not be considered. Because in this WT message, our name is not there. But in the earlier WT message, our name was considered, it was placed before everything was done. The NOC was obtained, everything was done, but that was not.
Yes, Mr.
Lordship, the impune WT message, Lordship. By this message only, the authority is asking for the NOC from the authority that these candidates they have not encroached over the government land, Lordship. And Lordship, what is the issue here, Lordship? The petitioner must not be agreed by this very WT message. What he can ask is he may be included in the Lordship this list, Lordship. That only he can ask, Lordship.
Why you are saying that
144, Lordship, is.
Why you are prejudging that you will not be considered? Your case will not be considered.
Our name is not in the list, Lordship, except petitioner number 1 and 2. The name of petitioner 1 and 2 is there, but they are at the bottom in the list, and they shall not be considered. Now, Lordship will say proposal for conducting DPC promotion for the rank of inspector APPS easy. In effecting reference to the above referred letter and the set of subject, I am directed to inform you that the vigilance clearance certificate and other records of the updated for conducting DPC promotion from the rank of inspector to APPS easy. In this regard, you are therefore requested to take necessary action and submit a fresh proposal for the said post, taking into account the posts which are likely to have occurred during the current year. Also, the documents are returned herewith for your necessary action.
Your name is on some of the petitioners' names are here.
Yes, Lordship, only
So,
2.
1 and 2 are there, Lord.
1 and 2 there.
So,
and it's also not the case of the petition that the names given here all are not the eligible. Does not come under the zone of consideration, Lordship.
Lordship,
most of them comes under the zone of consideration. That's admitted position, Lordship.
These 2 persons in the IRBN serial number 10 and 11, there will be only 3 posts, and this person shall not come into consideration in that case. These 2 persons shall not come into consideration.
Are you challenging the rule?
I am not challenging, Lordship, because my case is that our case may be considered as per the earlier rule, not by the new rule.
No, before consideration, how can you say
Because
that your case will not be considered?
Because that earlier WTO says everything was done, Lordship, on the basis of that.
Earlier rule. Where is that?
As per earlier rule, I am showing, Lordship. Page 74. Here from serial number 14, the names of the petitioner was there.
And what is the judgment?
At page, Lordship.
The judgment by this court. Column 5, page 185.
Lordship, by this judgment, there was direction to hold DPC within a regular interval.
In terms of the relevant guidelines procedure.
Yes, Lord.
Why you are
Debate will
annexing?
be held.
Why you are why you are annexing this?
Only for this, Lordship, there is some order observation. Debates will be considered and held as expeditiously as possible, and preferably that is in the because Lordship,
Why you are relying this? Why you are why you have annexed this?
only because in this case DPC was directly constituted shortly.
So
not for other purpose. This judgment. This page 185. It was done by civil police. In that case also, there are some deviation.
So
Lordship, now
you are in IRBN.
Pardon?
You are a IRBN, Inspector IRBN.
I am in IRBN.
So
Lordship, if DPC was held at that time also, we would be considered on the basis of this judgment also.
heard, Mr. Then counsel for the petitioner. Petitioners,
Yes.
you are agreed by the WT.
Yes, Lord.
Agreed by the WT message issued by the IGP within bracket ADM and PHQ eternal, page 147, 146. By which the NOC regarding non-encroachment upon government property and other relevant papers, including the ACR oblique APAR in original of the last 5 years till March 2025. How many persons of the and as well as the service particulars in respect of how many?
Five.
Now, how many persons here?
In this case, 5 persons, 5 petitioners.
Sir.
And this WT message.
For how many persons?
53, 56, then 10, 12, 56, 67, and 4. 71. Total 71. 56 in civil police, 12 in IRBN, and 4 in APPBN.
71.
71.
71 inspectors serving in the department. What I say? Agreed by the initial. The petitioners have filed this present petition.
In the seniority list also the petitioner was senior.
Huh?
In the seniority list also petitioners were senior to these persons.
Challenging, file this petition, huh? Challenging the WT message on the ground that three of the petitioners who were also working in the working as inspector, IRBN. Inspector IRBN
IRBN.
have not been called for promotion to the post of SDPO.
No.
Public
Entry grade.
Deputy Deputy SP, huh?
APPS entry
Within
grade.
bracket entry grade. Within bracket APPS entry grade, bracket close. Contending that the petitioners were entitled to be considered for promotion as per the rule.
Of 2006, Lordship.
What 2006 rule? As per the
Arunachal Pradesh Police
Arunachal
Service
Pradesh
rules.
Police Service recruitment rule.
Arunachal Pradesh Police Service Rules 1989
Service rule.
amended in the year 2006.
1989 as amended in the year 2006. Whereas the respondents are contemplating to consider contemplating to constitute a DPC for promotion to the Arunachal Pradesh so and so. APPSC entry grade under new rule.
Yes. 2025.
What is called Arunachal Pradesh
Arunachal Pradesh
Police Service Rule.
Police Service
Second
Amendment Rules. Amendment in bracket
2023.
2025.
Mr. Issue notice returnable by 4 weeks. As Mr. Estapil Lanet, senior government advocate, and first appearance and accepts notice on behalf of all the respondents, no formal notice will be sent. However, except was to be furnished to the land council for the petition. Are the respondents considering the submissions of the land council for the petition? It is provided that any promotion made pursuant to the WT message and as per the rule Arunachal Pradesh Police Insurance Rules 2022 shall be subject to outcome of the request.
Lordship, for one small correction, Lordship.
Yes.
Not 71, 72 in number.
72, yes.
72.
72.
Number 7.
Yes.
Impune order of the Secretary Land Management has midway obstructed the disbursement of the compensation of Beecham district.
Where it is?
Page 78.
78. Yes, what is this?
In partial modification of order number so and so dated 5th March 2025 district land
Type
settlement.
copy is page 79.
79. Sorry.
Yes.
Settlement officer of West Coming and East Coming are hereby engaged in disbursement process of Frontier Highway Road Strait falling on the Beecham district under proper supervision of the Deputy Commissioner Beecham district as per the arrangement mentioned below. The also West Coming shall be part of compensation disbursement for the road led from kilometer so and so to so part, package number 1, 2, and 3 of Bandila, 9th mile to Nafra and the Beecham district. DLRSO East Coming shall, my Lord Marcus, DLRO East Coming shall be part of compensation disbursement for road land from so and so, package 4 of Nafra to Lada Road and kilometer so and so of Lada to Surly Road under Beecham district. Now, my lord, very interesting thing, my lord. Before this, my lord, the chief secretary passes an order, but this has been superseded by the secretary, my lord. I don't know
How you are agreeing? Who you are?
You
are affected.
I am the land affected owner.
Land affected.
Because of their fighting,
This-
why I should suffer, my lord?
No, this is what it says. What's the wrong here?
The wrong is secretary do not have the power to direct, override the Land Acquisition Act. This is one thing. Second thing, my lord, just I will come to the fact that second thing, my lord, secretary do not, under the rule of business allocation of Arunachal Pradesh 1987, he do not have the power to supersede the order of the superior authority.
Now, how you are agreeing?
That's the aggrieved is, my lord, all
These officers are engaged for disbursement of the compensation account.
the great respectful submission would be, my lord, the Dilaraso East Coming district is nothing to do with the disbursement of the land compensation in another district. That is what the section, my lord, I indicate this. Section 3G.
Sir, appointing this DLRSO of East Coming district is coming.
That's why, my lord,
I will be prevented from accepting, receiving the compensation amount.
Just give me a moment, I'll clarify.
Sir, we have running out of time, and you tell us.
That's why I'm.
You are affected person. They are going to. The state is going to. Authority is going to disburse the compensation.
Therefore,
just tell us. Wow. If somebody is appointed to be the part of the disbursement process.
Therefore, my lord, because of this impugn order, earlier where the chief secretary superior order has allowed EAC Bana under Beecham district to act as a dealer.
Understand, sir. I understand.
And number two is that, my lord, then deed of execution agreement has also been done. Check has also been signed. Now, because of this impugn order, disbursement of compensation is being delayed.
So,
and then, my lord, will kindly come to page 87. This is what the deputy commissioner writes, my lord.
87.
The deputy commissioner writes to the secretary land management. Report on delay in disbursement of compensation against the frontier highway road, the stretch from so and so subject. I'll read from para 2, my lord. Thus, sir, myself and my dealers, so namely so and so, were making our best efforts to complete the payment of compensation process for the kilometers mentioned falling within Beecham district. Then on 6 June 2025, we worked whole day so and so, 99% of the process was completed. And as per the proposed launching, start of issue of compensation amounts by concerned beneficiaries by the Honorable Union Minister, so and so on 9 June 2025 at so and so hours at so and so ground Nafra, we had to finalize the compensation amount of 11 numbers of beneficiaries and checks for which are jointly signed in advance. Further, to speed up the disbursement process, the then dealer insured so and so had signed all the checks of our joint account in advance after completion of other related process. However, on June 6th evening, an order from Secretary Land Management wide so and so stating that the dealers of West Cummings shall be part of compensation disbursement for so and so kilometer mile, and dealers of East Cummings shall be part of compensation disbursement for the road from kilometer so and so road under Beecham district, paving the way for further delay in the process. Therefore, it is observed that at present scenario, if some other dealer is allowed to function as dealer of Beecham district, the disbursement of the compensation with the kilometers mentioned above will inordinately delayed, especially with regards to the management of checks and other related official documents, so and so.
What?
I am affected, my lord. I am the,
Sir, what type of deputy commissioner is this?
my lord, one more thing, my lord. I point out, my lord. Kindly see the order passed by the chief secretary. If I can just, my lord, kindly see the chief secretary order, page 65. 5 copies. Where is 5 copies? Is it visible? My lord, kindly come to page 65. Give my lord.
Yes.
Secretary cannot override the decision of the chief secretary, my lord. I'll place all the relevant rules.
First of all, how this writ petition is maintainable? They are the so-called beneficiaries. Either they get it through the DLRSO of Bichom district, East Coming district, or West Coming district. How does it affect
Okay,
them?
would that understand why this deputy commissioner?
Yes, my lord. And what it says in the
He
impugn
also
order.
doesn't want these persons, who is that, DLRSO of is coming to be part of this compensation disbursement.
My lord will see
And
impugn.
he says it's paving the way for further delay in process. And delayed in the mention above will inordinately delayed, especially with regards to management of checks and other related. These are all your official,
Official that
things you
these
should
are,
work
my
it
lord,
out. Why the secretary is writing a letter, appointing it, and the deputy commissioner is writing back to that secretary that if this person is appointed and
my lord will
allowed
see
to work,
in the
what's
impugn
the
order
reason
itself.
behind, in fact?
That's why this, in fact, I believe this should have been a writ petition by the DLRSO Lada. In fact, my lord will see the impugn order. What it says. In partial modification of order number so and so 5th March 2025, that district land settlement officers of West Coming and East Coming are hereby engaged in the disbursement process of frontier highway road stretch falling under Bichom district under proper supervision of Deputy Commissioner Bichom district. Whether it is the DLRSO from West Coming or East Coming.
You are agreed by the clause B,
Correct.
clause B or clause A? You are from,
B only for dealers.
you are the affected
I am from Bichom district, my lord.
Bichom district,
Yes.
obviously. Which
And then
one?
what is the role of this DLR?
Which one? Which one? A or B?
B.
Your land is here at Lada to Charlie Road.
Correct, my lord.
Huh?
Correct.
No, Nafra to Lada Road and Lada to Charlie Road. You don't want this dealers is coming to be the part of the compensation
Correct, my lord.
disbursement.
Because in the Lara Act also,
No, it's okay.
officer from one district.
It's only for disbursement.
No, my lord, he cannot because
What's the reason behind? Why you are not interested?
there are complaints against him, my lord. There are so many complaints against him, including the DC, and both of them are facing inquiry, my lord. That is my instruction. It has been brought.
Heard Mr. Titi Tara. Well, you should notice. We're not happy with.
Yeah, but they're locals. In fact,
Yeah,
it's
it's okay. We understand, but then your action is also the particularly deputy commissioner. These people, the officers will be work under him, and he's writing it to the secretary saying that it will cause inordinate delay. What sort of deputy commissioner is this?
That is the reason why, my lord, we have filed it. Because of your fighting, I am a beneficiary. Why I should suffer? You sort it out.
So it's not. There's no question of there's no question of interference. But then we'll say tendency shall not be barred to go ahead with the disbursement.
Correct.
That will say.
That's
Is not it? Will
correct.
not say anything on this thing.
That is more than sufficient for me.
Heard Mr. Titi Taralan, counsel for the petitioner, claims to be agreed of the, what is that?
Land affected,
Page-
sir.
page 79.
79. My lord will kindly have my list of dates. I have made it very clear.
Claims to be agreed by the order dated 06/06/2025.
Correct.
Passed by the Secretary Land Management Government of Arunachal Pradesh, whereby the land settlement, district land settlement officers of West Kameng and East Kameng districts have been engaged in the disbursement process of frontier highway road estates falling under Bicham district under the proper supervision of the Deputy Commissioner Bicham district. This present petition is instituted on the ground that such an engagement of the DLRSO or DLRSO district land settlement officers of other district has caused a delay in the disbursement of compensation. Issue notice returnable by. No, although Mr. N. Ratan, Additional Advocate General, questions the locus standi of the petitioner in challenging the official order of assignment of the work to the petitioner and to the officers by the competent authority, considering that considering that strangely the Deputy Commissioner has written a letter to the Deputy Secretary Land Management expressing that if the district land management, land settlement and district land, what is this?
Land
and Revenue Settlement Officer of East Kameng
Land records
and West Kameng are engaged in the disbursement process. Same would cause inordinate delay in the disbursement process, issue notice to the respondents.
To the
respondents. All the respondents.
District land revenue and settlement officer. Land records and settlement.
Land records. Land record and settlement officer. Issue notice to the respondent. As the respondents are represented by, as the respondents are being duly represented by Learned Additional Advocate General, no formal notice need be issued. However, extra copies be furnished to the learned pending disposal of this writ petition. No, the issue of locus would be considered on the next date and next para. Pendency of this writ petition shall not be barred to proceed with the disbursement process to the of the compensation to the land affected people of the Bicham district.
On the basis of the impugn order?
No.
No, will not say anything. Your deputy commissioner is not happy with these two officers, appears to be. I don't know why.
Correct. Great.
Yes.
My lord have already dealt in item 4.
Same issue.
No, my lord.
You are L2.
I'm L2.
Same.
My lord, no, my lord.
The right of the L1 has to be determined.
Sorry, sir.
No, my lord, I will project. Please afford me 2 minutes.
Yes,
I'll not take more than that.
we cannot discriminate.
No, my lord.
The only difference is you are L2.
My lord, Well, kindly there.
Well considered.
No, my lord, kindly give me 3 minutes time at least for one interpretations with relating to the.
We cannot do it. We'll issue
Well,
notice.
kindly allow me to, kindly allow me
I
to.
may agree, you may raise a very valid point, but we'll deliver it only. Let them file their response. Right?
No, huh?
Let them file their
No,
response.
no, my lord, what I am trying to convince my lord is
Yes.
on one count,
Yes.
because there is an interim order, interim prayer.
Interim
Although my
order
lord, no,
was not granting.
no, my
Okay,
lord, I
okay,
respectfully
okay,
agree
please.
with my lord's view,
Make
my
your-
lord concern,
make your
because court cannot do injustice to another litigant, my lord.
Not
Thus, I
necessary.
respectfully agree with this. This is settled position of law. My lord, only thing is, my lord, kindly have page 50. Page 50, clause 14. I'll give my interpretations and then I'll finish it off.
Page 40.
50 SBD.
Yes, 14. Awarding of works.
Awarding of the works. Well, I'll demonstrate. I'll not read that, my lord. Clause 1 also I'll not read if there is a paucity of time. But if my lord allows, I would love to read this both the clauses. The tenders shall be evaluated by the boards constituted by DC cum DPC at district level and recommended at least 3 forms L1, L2 and L3 to the competent authority for accepting along with all relevant documents. 2 is important for us, my lord. The joint director RE shall further scrutiny the tender documents. My lord will mark word scrutiny and I will differentiate the meaning, lord. Scrutiny the tender documents recommended by project director. The LOI shall be issued to L1 firm if the tender documents recommended by the project director is up to the satisfaction of acceptance of the authority. Now, my lord, I have done my research. What is the meaning of word scrutiny in terms of tender evaluation, my lord? The scrutiny and evaluations are distinct but related process. Scrutiny is the initial, often preliminary review of tender documents to ensure that they are complete and compliant with basis requirement. So therefore, literal meaning is that these joint director RE do not have the power to reevaluate the tender. Your duty is only to the extent whether there was a compliance or not, my lord. Secondly, my lord, what is the meaning of evaluation, my lord? Evaluation is a more in-depth assessment of the proposal based on predefined criteria to determine the most suitable bidders. This is the definition that I got from Blake Law Dictionary, my lord. Now, therefore, once the evaluation is done at the district level, deeper analysis has been done, and your guidelines does not give you a permission
Accept.
for re-evaluation. No.
Accepted.
Re-evaluation. So therefore,
No, all your submissions are
yes,
accepted.
even if he has found some difficulty, then also if he has some concurrent finding, different finding, then he should refer back to the district level.
Yes.
He do not have the power.
Yes.
So therefore, this is on the teeth of this guideline itself. Prima facie illegality is being committed.
Accepted. Then, who are you?
I am L2.
L2.
Yes.
What is your right?
My right is that
You said it
he
should
has
be-
already raised his objection that the L1 does not have the.
You wait for L1.
Yes, sir.
Once
No,
L1
my
is
lord, sometimes-
rejected, then you come.
You know, my
sit in
lord,
the district.
why I am saying is sometimes prima facie on the records and the
Sir,
rule books.
Sir,
But because of taking
prima
shelter of this,
prima facie-
misinterpreting, you are
Sir,
committing mistakes after
prima
mistakes.
facie,
in the department.
all your submissions prima facie appears to be correct. But then what is your right? When you are not L2. What do you say?
My right would be,
For a moment you forget whether you are L1, L2, L3. Who should be given?
primarily it should be L1.
Then
Correct. For a moment, please. For a
the moment it is not
the moment
rejected.
L1 moves out from the bidding process, then my right accrues.
Yes.
So therefore, my lord, I have a right to maintain this petition. my lord.
That's why all your submission would be in a, had you been an L1, a judge as L1, then immediately will stay the process.
Correct. my lord. That's why when I saw this, when
Different will be? that is item. Let us save time. Item 4, huh? Same order. In place of L1, it should be Mr. Titi Tara so and so, so and so. Same order. In place of L1, it should be L2 in this order. Okay.
My lord, on next date of listing, interim shall be considered.
No.
Kindly, my lord.
Then I'll reject it.
No, my lord. Please, my lord. Please, my lord. That at least that much request, my lord, can consider.
Sir, come.
At least, my lord.
Sir.
For equity.
No.
Please.
Same order, it will be subject to outcome of the rate petition.
My lord. My lord, may I kindly request?
You file the affidavit.
My lord, when it is listed?
Within 2 weeks.
Yes.
2 weeks.
No, 1 week. Well, it should be because
overloaded 1 week. No, it's a similar.
2 weeks, 2 weeks, my lord. No.
10 days, 10 days.
10 days, correct, my lord.
10 days.
Because they cannot be given because.
And we cannot take up all the cases in a day or two. Therefore, last one is Mr. Pangi's case is 1 week.
Yes.
Their case, this item 4 and 7, 8. After within 10 days.
10 days.
10 days.
Within 10 days, my lord. And whether he files affidavit or not on law point,
But we'll first consider this L1.
Yes.
We'll first consider the L1.
L2.
And you don't make submission on behalf of the L1.
And
you will make a submission for L2 only.
And by the time, my lord, much water will be flown beneath the bridge. That much I can ensure, and I'm sure to secure an order from this portal.
I think this court has caught you rightly in the morning.
You
are L2. You want to argue first.
I could make it out, my lord. That is the predicaments of our part, my lord. What we do.
It's a niceties of our profession.
Thank you. God bless you.
Yes. 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 What is this?
My lord, what has happened before coming to IA, my lord?
Application seeking direction against the opposite party not to issue vesting order till disposal. How can we write first like this?
My lord, I'm coming.
We'll just issue notice. Sorry, sir.
My lord, this is the because the matter is pending and this honorable court, my lord, bear with me.
What this honorable court has directed?
My lord?
At the initial stage.
Because, my lord, they are going to issue
sir.
vesting order. Why? Because
is there any order?
My lord, your lordship may kindly come to first order.
Disclosure with the interim order.
Page 16. Page 16, your lordship may kindly see. Page 16.
Yes, page 32 or
page 32 is the final. My lord, can I say 5 minutes? Brief, my lord, 5 minutes, my lord. My lord, 16 is the order where we approach this honorable court and this honorable.
There is a stay.
Pass an order, the finalization of the without leave of the court cannot be done. Against this order, my lord, they prefer.
Where it is?
My lord?
Where it is?
It was passed on 17/3/2025.
Ah.
Thereafter, against this order, the successful bidder approached this honorable court by way of writ appeal. And in writ appeal, this honorable court, page 18.
Where is the stay?
And what this division bench of this honorable court has done.
Sir, page 16, this order that is 0204, where is the order of stay?
Stay, it was modified by division bench, my lord.
Ah.
Page 18. It was modified para 6, my lord, page 20.
Ah.
Having noticed that no regions have been assigned in the order dated so and so as to why the tender process should not be finalized without leave of the court, and that the court has not recorded its prima facie satisfaction with the entitlement of the petitioner for granting interim relief. This court is inclined to stay the operation of the interim order dated so and so. Accordingly, there shall be no bar for the authorities to finalize
the tender process without
the tender process without leave of the court. They can finalize. They have already finalized. However, the stay is made conditional by providing that the finalization of the tender process shall be subject to outcome of the writ petition. The stay is also on the condition that the applicant shall file an undertaking in the form of an affidavit within a week from the date of this order before this court abide by that whatever direction that may be passed in the connected writ appeal as the finalization of the tender process is made subject to outcome of the writ petition. Accordingly, my lord, they file affidavit that your lordship will see at page 25. They will abide by the finalization because finalization has been done. Thereafter, ultimately, this honorable court, page 29. dispose of the matter on the basis of para 6 or judgment given by division bench para 6, your lordship. And interim was continued till the disposal of the writ petition. So tender was finalized, agreement they entered.
In
Now
view of the above, order dated so and so passed in IA. So and so, nothing severe in the appeal. According to taking note of the submission, non-person. Considering the fractions argument, the discord is going to close. Now the dimension is interim stay granted by the order so and so passed in IA number 90 and the condition therein. The evaluation of
my matter was moved on 17/3 till today, my lord. Respondent they have not filed any affidavit, my lord. On the one hand, they have not filed affidavit. On the other hand, they are proceeding.
Sir,
my lord.
Till the finalization of tender process shall be subject to outcome.
Yes,
of writ
so they are
petition.
already finalized. I am not
Sir,
on that. What they, now?
What we may finalize? Finalize includes the vesting.
No, my lord. Vesting is not the finalization. Is agreement entered into that you are the L1, you are L1. So we are entering into an agreement. The moment the vesting order has been passed, my lord, what will happen? All the, my lord, land, mining activities, they will start. Or what is the harm, my lord, if the writ petition is disposed of in 1 week or 10 weeks, but they have not filed affidavit? What is the urgency, my lord, that it has to be given issue? It has to be issued. My lord, I am saying let the matter be taken up on Monday. Your lordship may hear it. But till then, my lord, it should not be, my lord, because we inform the authority that we are at the mercy of this honorable court.
You are relying on seeking and stay of the vesting order.
Vesting order, my lord.
Vesting order in view of the order of this court.
No, my lord, vesting order is
the division bench.
My lord, vesting order is different.
I am saying,
my lord,
your basis is the order of the division bench, which is directed that the condition therein that finalization of tender process shall be subject to outcome shall continue as provided in para 6. You read, you have read para 6.
I have read. What I am saying, no, my lord, I may be wrong. I may be wrong, my lord.
Include everything.
My lord,
just not the half, just be a decision. And you will not award.
So far, my limited understanding, my lord.
My limited understanding
I
is
may not
also
be-
finalization include the completion of work also.
Completion is different, my lord. Handing over to the site or not filing affidavit
everything,
here, not
everything.
filing affidavit, delaying the matter.
No.
And at the same time, my lord, they are, my lord, ultimately, because if your lordship is
If
there,
you
it is-
want early hearing, we can decide.
My lord, it is,
Decide the matter.
my lord, it cannot be irreversible, my lord, it is. The moment it is,
I cannot change the division bench.
I am not saying to
Order.
change, but what I am saying, my lord, this vesting order, division bench says finalization.
Where is the vesting order?
My lord, they are going to pass, my lord, today. They are going to pass. We have made the averment. It may be inquired, my lord, from my learned friend. Because we inform that we are at the mercy of this honorable court, they are waiting for the outcome of today's hearing. They are going to pass. I have given averment in the writ petition.
Sir,
my
it
lord.
would be very strange to say
My lord.
and interpret that finalization is only a decision to award.
My lord, if that
without
is,
awarding.
my lord, if that is so,
That
all
would
the
be-
mind,
that
if
would-
they,
That's
my lord,
that's it.
my-
See, reason is very simple. It says subject to outcome. What does it mean?
3,000 crore.
Let them finish everything. If we decide this court,
By
they have
that-
undertaken that they will abide
My
by
lord,
the obviously they will
my lord,
abide
by
by
that
this
time,
court.
3,000 crore rupees will be, it will be my loss to the government. We
We are
are
not concerned.
my lord, page 11, your
We are not
lordship.
concerned.
My lord, in
Now
the,
at the moment we are concerned about the order passed by this court, subject to outcome. Finalization will be
Finalization.
subject to the outcome.
not vesting order, my lord.
So finalize that means
My lord,
what?
in that case, my lord, I have to challenge vesting order also.
Yes, you challenge it.
My lord, that order is not in existence. They are going to pass, and the moment it is
You-
passed, my lord,
You get this, how you have.
my lord, for a moment, I'm,
Sir, it's your.
your lordship, whatever the order your lordship, my lord, kindly see page 11 for a moment, my lord. Page 11.
Yes.
My lord, here I have given chart, my lord.
Ah.
My lord, I am ready to give double the amount, whatever
No, no, we're not.
my lord. My lord,
This IA we're not.
my lord, Ram and Syam, my lord, open court, my lord, it is bidding was done in open court, your lordship. And here I have given 3,000 crore rupees is going to,
We'll take it up. We'll issue notice, you take obtain instruction.
when your lordship will take up.
Friday. For IA.
this Friday on 28th.
Prima facie, I'm not persuaded, I'm not convinced. Because your basis is that the division bench has directed to maintain the order passed by the in
Can
the-
it be on Monday,
this case,
Madam,
which
can it-
says that finalization shall be subject to outcome of the writ petition.
My lord, it is like that, my lord. May I, in the
It's,
lighter,
it's against you. Therefore, it is not, in fact, immediate staying of the process.
my lord, in the lighter side, may I say?
And it is always subject to outcome.
True, my lord. My lord, in the lighter side, may I say something, my lord?
Yes.
My lord, divorce petition is pending.
Hmm.
You are allowed to remarry.
Yes.
But your remarriage shall be subject to outcome of divorce petition. It is like this, my lord.
Yes. What can help it? It's ordered by the division bench.
My lord. I am at your lordship, whatever your
I'm
lordship.
not in
On Monday, my lord.
division bench. Or you are basing your division bench order is in fact against you.
My lord,
You will
that's
have
why-
to wait. Your only way are to challenge this order or to get the expedite
Or your lordship
expedite the hearing of
my
the
lord,
writ petition.
your lordship may observe that in view of the division bench judgment, your lordship today is not inclined to pass interim order.
Huh?
If your lordship may observe that in view of the division
No,
bench
I want them to obtain the instruction because if I pass any order, it may.
on Monday, your lordship.
Or if you want to consider and reject, I've indicated. I'm not convinced.
My lord, that's why my
To
lord.
state a vesting order.
What I am praying, your lordship, Monday, later
Monday,
matter,
huh?
Monday,
You
till
obtain
then, my lord, till then, assurance, my
And
lord.
you
Till-
may
inform
you may
that
file
not to-
your affidavit also.
no, not file affidavit, my lord, till today. In
That's
the,
why.
my lord, till
Heard
Monday,
Mr. A. Goyal, learned counsel for the applicant writ petitioner. Right?
my lord.
Division bench
I was
order
not
is
there, my lord, in that day.
against you.
Without
Huh?
issuing notice, division bench.
Division bench approached by whom?
By successful.
Successful bidder. You are unsuccessful.
I am unsuccessful at the time of that, my lord. My bid was
By
high.
filing, this is an application paying for stay of the what is called vesting
Vesting order.
Vesting order.
V for victory.
Vesting order till the disposal of the connected writ petition being WPC 109 of AP 2025. Stating that the respondent authorities, despite the order of division bench directing continuation of the interim order granted by the order dated 02/04/2025 in IAC number 90 of 2025 and the condition therein that finalization of tender process shall be subject to outcome of the writ petition. As shall be continue, please stop. The Mr. Amit Goyal, A. Goyal, learned counsel by the applicant submits that despite the operation of the interim order, the respondent authorities are in the process of issuing the vesting order to the
Today, I am told.
today.
Today or tomorrow, my lord. Any day, my lord. In a day or two, your lordship.
On the
In a day or two.
in a day or two, therefore phrase that the matter the respondent authority the process for issuance of vesting order maybe stayed. Issue notice returnable by Monday. Mr. M. Kato, DHI to obtain instruction. This is by the government of India.
Government.
Authority to obtain
All
instruction. Obtain instruction. On that day will pass.
Your lordship, till then,
Rejecting or
just inform,
accepting.
my lord, just inform that not to pass order. I am not saying any order, just assurance, my lord, that he will inform. That much yours. I'm not saying to pass.
You are not, you are
On
not-
Monday, your lordship-
you are not, yourself is not sure. Day or two, you said.
My lord, please, my lord,
Not me. You.
It is my request.
Kindly,
Monday will not, heaven will not fall.
My lord has already observed, only my lord not mentioning some the vested order in the my lord, the order passed by.
Heaven will not fall in 3 days, my lord. Monday till Monday, for my satisfaction, my lord. At least I have come from Guwahati. Please. Deeply observed. It's pleasure, my lord, appearing before your lord.
Yes.
Yes, may I lordship. May I place your lordship.
Yes.
Lordship, since we have received the copy of affidavit in opposition filed by the respondent number 1.
Yes. So.
So Lordship, we may allow some more time to file a
On
revision.
the prayer of Mr. So-and-so, learned counsel by the petitioner, 3 weeks' time is granted to file affidavit in reply. MS so-and-so, learned state council is present.
Well, before the learned senior counsel starts, my lord, I have an instruction that by last order, the learned additional AG was directed to produce a record. Record has been brought in and produced today. But my client says, my lord, let the government file it in the form of affidavit so that in order to make things more clearer, my lord. That is my instruction. My lord. I cannot go beyond the instruction. And interim order, if they are enjoying, let them enjoy and list it on, my lord, 4th, my lord.
4th of
July. Let them enjoy.
What do you say?
My lord, if you lordship Paris last order, what my brother is saying, my lord, 2 options was given to us.
Correct.
Either to file affidavit or to produce the record.
You are
My lord,
private respondent.
the private respondent, my lord. Now, my lord, filing affidavit will not change the records because record will speak its own. So I brought the record. If lordship wants to peruse, my lord, matter can be disposed of.
My client, I have to go by the instruction of my client. I
No,
cannot-
in that case, since they have the original record, we'll ask him to keep with him and retain the record.
Fine.
If you want some other day, if you have difficulty today, we'll peruse the record on that day.
Well, then my client.
Otherwise, are you ready for going the
Issue is
matter?
not that big.
If you are not ready, we'll grant you time.
No,
Interim is in your favor. Interim order is there.
Yes.
It's okay then.
That was the instruction because if I act beyond the instruction.
And it's okay.
I will be.
It's okay.
But the instruction sought by the client
Yes.
cannot supersede the order which has already been passed by the court.
It's okay.
As per the order dated on
I'll come back.
6/6/2025, it is clearly written that respondent number 1 to 6 submit that he may be granted 2 weeks time either to file affidavit in opposition or to produce the record before this court.
Raise a law.
Well, 19. I'll come back on 19 with the instruction. If
19.
19.
No, 19 is not
The
possible.
client-
He has already filed affidavit. No, he don't require any more
Who?
instruction. This
Who has filed affidavit?
respondent.
Okay. Heard Mr. M. Pertin, learned senior counsel assisted by Mr. M. Pertin Jr. Huh? Or should I pull your full name? Mubang Pertin. Mugbang Pertin. Learned counsel for the petitioner. On the prayer and Mr. Next para, Mr. Aris Nabam, learned additional advocate general.
19. All right.
Submits that he has obtained the records as directed by this court and is ready to produce. Please step. However, Mr. Titita, learned counsel for the respondent number
7.
7 has expressed difficulty today to to argue the matter, for argument of the matter, therefore prays for adjournment of the matter for 2 weeks.
No, but,
1 week.
but I'll come back with the instruction. If not, because my client is in the.
No. You have filed your affidavit.
I have filed.
Record is
Record is
up to
okay.
the court. No issue. It will be seen. It will be
The
whatever
24
they.
24. 24 for disposal.
Not will not say this point. Listen after a week.
What
After a week.
tomorrow?
After a week.
Sir, let me seek instruction, sir. 24 Miller. Can you please, 24?
24.
24.
Make it 24.
Let interim order, he can enjoy the
Interim order first, I'll
Yes.
say continue. What's your entry, please? Yes, sir.
The respondents have to file affidavit on opposition today.
Yeah, fine.
You have
Ah,
filed?
Yes.
What is your stand?
Your Lordship, we are saying that the matter has been taken up with the competent authority for clearance the bill, Your Lordship, but till now, Your Lordship.
Yes.
It's because of non-allocation and non-placement of fund, Your Lordship, we have said.
We will dispose of the matter. We'll dispose of the matter when you have stated so. Legal notice, where is
Paragraph 6, Your Lordship, and 10.
para?
Paragraph 6 and paragraph 10.
The incentive fund is due to non-allocation and placement of fund from the pending bills could not be made on time.
Yes. Paragraph 10.
This is the legal has been received from you for clearance pending in the matter is taken up with the. Otherwise, it's admitted. Amount is
It's-
admitted.
Yes, Your Lordship.
Yes, we're disposing within 5 months you pay. 5 months.
Yes,
Right.
my lord, this is the matter of
5
the
months. Well, we're disposing of the matter, allowing the repetition and directing them to pay within 5 months. All right,
Lordship.
because it is not disputed. Heard, Mr.
GC Taba.
TC Taba.
GC Taba.
Taba, learned counsel for the petitioner. And also heard MS R. Bassett, learned counsel for the legislative counsel for the respondents. All the respondents.
Yes, all the response.
By filing this writ petition, the petitioner has prayed for a direction to the respondent authorities for payment of outstanding bill amount of rupees 71,47,575. You write in words also, bracket close, with interest at the rate of 18% per annum with effect from 28/4/2015 for the work. What is this? What is the work? What is the work? Name of the work?
Maintenance
For
of
the-
various roads.
For the work, for the execution of the work of maintenance of various roads under Daimuk PWD within bracket para 2, huh? UPA district headquarters, so and so, huh? Issued by the executive engineer PWD Daimuk division on being approved by the competent authority of the department. Mr. GC Taba, learned counsel. No. The case of the petitioner, next one, huh? Is that is that the petitioner is the proprietor of Messrs. Basu Enterprise, a government registered firm with its headquarters in this sector, Naharlagun, engaged in the civil construction works under various works department in the state of Arunachal Pradesh. The petitioner was awarded the work contracts for execution of work so and paragraph and the details. With the details, sir. Paragraph, you put the paragraph. List of. It was issued as a bio work order. There is no tender, nothing.
No tender.
Mr.
Agreement was done, agreement.
Above works have been awarded after acceptance of the quotations offered by the petitioner by the executive engineer, PWD division, by work orders against each of the packages as indicated herein above. Mr. It is the Mr. So-and-so counsel for the petitioner submits that the works, the above works have been duly executed by the petitioner. However, the respondent authorities have failed to make payment of the bill amounting to rupees so-and-so, 71 lakh so-and-so, despite several approaches which has caused financial hardship to the petitioner. Whatever that, आने वाला मार्च में दूंगा. What is this? Huh?
They are saying.
You don't have to write everything here. Therefore, he submits that the respondent authorities may be directed to release the outstanding bill amount of rupees so-and-so within a forthwith, forthwith. Next period. MS Arbasar, Land Council for the respondent, Land State Council for the respondents. We are referring to the statement, to the affidavit of official, well, on behalf of the state, on behalf of the respondents, submits that although the amount claimed by petitioner is not disputed, however, due to non-allocation and non-placement of fund from the government, the amount claimed by the petitioner could not be made on time. She submits that the matter has been matter is being taken up with the competent authority. No, the matter has been taken up with the competent authority from time to time for placement and allocation of fund for clearing the outstanding bill of the petitioner. However, as of today, no fund allocation is made, and due to non-availability of fund, the bill amount could not be paid to the petitioner. She further submits that as and when the fund is available. The bill, that will not. Last line delivery. Next paragraph. Admittedly, the petitioner has executed the work for construction of construction of work of maintenance of various roads under dynamic PWD division. You give all this thing, not the figures. On being after accepting the quotations submitted by the petitioner by the executive engineer, PWD division. PW division, by work orders, Mr. The amount claimed by petitioner by work orders for which an outstanding of bill amount of rupees 71 lakhs is due to the petitioner. Next paragraph. Having considered that the amount claimed by the petitioner is not disputed, rather admitted by the respondent authorities, and having found that the petitioner has executed the works as per the work orders issued by the respondent authorities, I deem it appropriate to allow this petition with the direction to the respondent authorities to release the amount claimed by petitioner. Mr. You just mentioned the year. Which year it was?
2015.
2015. You have
No,
completed
we
in
get
2015.
2015. Work has been carried out 2015.
Okay, 2015. Work is so and so. Work
Till
is-
the decades has been crossed.
No,
10
why,
years.
there's a reason do you realize? If it's delayed, if it is barred by limitation, we cannot interfere. We cannot direct. Anyway,
Okay.
that's the reason I'm asking. Accordingly, the respondent authorities are directed to pay the outstanding amount of rupees so and so to the petitioner within after. No, they were directed to verify, verify the claim of the petitioner, and if found entitled, shall pay the amount within a period of 5 months from the date of receipt of the certificate of the disorder. States this further.
Thank you, my lord.
My lord, as per last order, my lord, I have taken Dusty, my lord.
Okay. Heard Miss learned counsel for the petitioner. Petitioner has filed an affidavit with regard to the proof of dusty service upon the responding number
13 and 14.
Proof of service of notice by way of dusty mode, by dusty mode upon the responding with 13 and 14.
Yes.
Please go. Where is the last day? What is this affidavit? They have received it.
Yes, my lord.
Have they received?
Yes, they received, man.
Where it is? Where is this? This is affidavit of opposition. Where is that? Page. Where is the receipt? Okay. P. Rambia. Who is P. Rambia?
P. Rambia is respondent number 13, madam.
Okay. What about 14? Wangmu Tongdok.
Yes, ma'am.
Huh? Okay, next page. Tracy, okay. Perusal of the affidavit. Particular of the perusal of the affidavit. The perusal of the notice issued to the respondents, number 13 and 14, as annexed in the affidavit. So that the respondent number 13 and 14 have duly received and accepted the notice. Accordingly, the service in respect of respondent number 13 and 14 are treated completed. Are treated complete. Then you are appearing for 13 and 14.
No, for at 3 and 4. Respondent number 3 and 4.
So what is to be done? 2015 matter.
Yes, sir.
What is the matter?
Well, this is promotional matter, madam.
List for admission in after 3 weeks.
Yes, madam. Okay.
Please, madam.
Affidavit, have you filed the affidavit?
No, I am for the petitioner.
Huh?
I am for the petitioner.
Yes, affidavit filed by.
Regarding dusty service, I have filed already in previous occasion.
You have filed?
Yes, dusty service I have filed.
Ah,
Even I
yes.
tracking
This is
report.
so and so, so and so. Then what do you want?
This is tracking report. It's
Huh?
already delivered.
Yes.
Tracking report of the service upon respondent number 4.
Why you have not annexed along with this?
I think has already delivered.
Huh?
I think has already delivered to the address.
Not the dusty against whom?
Respondent number 4.
How it is? Where is the receipt? Where is the receipt?
Receive it maybe in the file level.
It's not there. Where is your the affidavit?
My lord, last occasion I have already filed affidavit regarding dusty service. And this tracking report is.
No, dusty service taking dusty survey, you'll have to annex the report, receipt, that the respondent number 4 has accepted the notice. They'll put their signature. Then only you file the affidavit.
Your notice was delivered, but the respondent number 4 is denied to acknowledge the receipt copy.
Where it is? Where have you mentioned that?
In my affidavit.
Is by the election has taken decision upon us to address election and the same has been received. However, when the petition asked for the he denied to put his service service. The petitioner has filed, the learned counsel of the petitioner has filed an affidavit with regard to the proof of dusty service list of, according to the petitioner. According to the learned counsel of the petitioner, the respondent number 4 has already has received no, according to petitioner, he has taken justice service upon the respondent number 4 on 03/03/2025 at his residence at Serba, which has duly been received by respondent number 4. However, on being asked for acknowledgement, the respondent for had denied to put his signature. Therefore, the service may be treated as complete. Mr. Having considered the statement made on oath in the affidavit with regard to the proof of justice service upon respondent number 4, as well as this is delivered.
Yes,
Mr.
delivered.
As well as the considering the postal, is it what you call it? Postal tracking postal. Huh? What do you call it? This is track consignment, huh?
Yes.
Postal track consignment report, which shows that the delivery to the address. The service of notice as and service upon respondent number 4 is deemed to be his status complete. This for admission in after 3 weeks.
My lord, I am appearing for respondent number 2 and 3.
2 and 3. Then you so.
Lordship, I am for respondent number 1 appearing on behalf of M. Partner.
You read that then only list for admission after 3 weeks.
Much obliged.
My place was. Those for office note. The service up to respondent number 3 is still awaited.
So
I
what
have
is to be
taken
done?
press step.
Huh?
I have taken press step on my lord 14
On when?
14 May.
14?
14 May.
14 May.
Yes.
Well, this is with relation to item number 16, my lord.
No, no.
Item number 15, my lord. 15, my lord. My lord, there's
Whatever 14.
14 my lord, the
Pleadings is
pleadings are completed.
15, my lord.
15, 16, 16.
In 16 my lord, pleadings are completed.
There's no private respondent.
Private respondent, there is no.
My lord,
There's no private. And then?
My lord, in item number 15, my lord.
Uh,
Service upon respondent number 3 is my lord.
actually, my lord, 15 is the block development officer, my lord. So, but he has been made respondent as, by name, my lord. So otherwise, I can represent, my lord.
we'll have to wait for that. Since it's made
Some allegation
by name. Heard Mr. H. Lampu, Land Council for the petitioner, and just which 1, 2, 3, 4
I am
in item 16.
15.
15, okay. Okay.
For 5 and 6. Item 15.
Who is this is in respect of whom?
item number 15.
Respondent number 3.
I am for 1 and 2,
number
my lord.
15, my lord.
Anybody is appearing for 3?
No,
My lord, I can appear, my lord, because he is the block development officer.
By name, it has been made by name, sir.
My lord, yes. In my lord, because why, my lord? In item number 16, my lord, they have not made any allegation, my lord. Now subsequently they have made allegation, my lord.
As
Against
per
the video.
office note, the 16/6/25, service repair in respect restaurant to this level. List after 4 weeks.
Yeah, my lord, I have, my lord, yes, actually, my lord, what happened, my lord, on the last to last occasion,
My lord has,
There is stay operating.
no, my lord.
Then,
No, work has been completed. my
then,
lord.
so,
My lord has asked me to produce the original records, my lord.
My lord,
so what is your view?
actually, my lord,
Works
it
are
is,
completed.
I am-
what can we do?
It
What
is
can we
difficult
do now?
for me to.
but my lord, since my lord, I have made allegation against the respondent number 3, my lord.
You file a damage.
Yes, my lord.
No, my lord. No, my lord.
What is this?
Completion certificate, my lord. The original records, my lord.
Yes, nothing.
I cannot retain this for all the time, my lord.
No, my lord. My lord, since my lord, I have made my allegation against respondent number 3, my lord. My lord, I have made a specific allegation, and there is misleading awardment made by the respondent number 3 in item
You
number.
avail the appropriate remedy.
My lord.
You approach the appropriate forum
No, my
by our appropriate application.
In this matter, half of the payment has already been done.
my lord, that
No,
will
we're
not
not
absolve
concerned
my lord.
about the payment. Whether if the work is completed,
is going to be
nothing,
completed.
nothing remains.
Yes, my lord.
But my lord, in my humble,
What can I do? Is there any interim order?
No,
my
my
lord,
lord.
there is no any interim order, my lord.
So-
But subject to outcome is there.
Huh?
Subject to outcome is
Hmm.
there. My lord, since my lord,
Think over it.
Yes.
List for admission hearing, admission after 2 weeks. Think over it. We'll wait for
but
some.
my lord, regarding
Is
my
the
lord,
record? Is the
Yes,
record?
sir. Original records, my lord.
but regarding my lord, this notice upon this respondent number 3, my lord, since my lord, allegation is made against them.
That's why you have taken steps. We will wait for 2 weeks. Another 2 weeks. All right.
My lord.
All right.
Number 17.
I'm not seeing this, right? Hmm? Huh? Seventeen.
Yes, yes, yes.
Yes.
May I please, my lord,
Can you have it tomorrow? In
lordship.
fact,
Yes,
it has slip of my that thing. Yesterday I could not see it.
yes, lordship, because I still have to, I still have got certain more submissions.
Huh?
With regards to last time I finished till this right to know the candidates. Other issues are also there.
Tomorrow.
Oh.
Tomorrow
All right,
or day after.
lordship.
Day after tomorrow or day after. Day after, make it day after. Thursday.
Lordship,
Thursday.
day after Thursday, there is another election matter, election petition. So can it be on 23rd then?
23rd.
Yes, Monday.
Monday.
Yes.
Has agreed to go. I must heard Mr. This IA is for IA by the return candidate.
Yes, return
Respondent,
candidate.
number
For-
1.
Yes.
Heard Mr. We'll record your name. The learned counsel for the applicant respondent number 1, and also heard Mr. Learned counsel for the opposite party of the election petitioner. Petitioner. Mr. has agreed to be learned counsel for the parties. Let this matter be listed again on 23rd 06/2024 for further consideration of interlocutory application number
71 of 2015, huh?
Deeply obvious.
Matter number 23.
Yes.
On the last occasion, my lord, this matter was also fixed.
May I please your lordship? I am for the petitioner in this case.
No one appears for the petitioner on call.
Yes, your lordship.
You did not appear last occasion.
Yes, your lordship. I could not able to connect on that day. My connectivity is totally not.
Where are you from? Where are you from?
Yes, your lordship, from Guwahati itself, your lordship.
Then why don't you join? It's very difficult
Yes, your lordship.
because of the issue, net issue or something like that. There's a technical problem. It's very difficult.
Lordship, I will try my level best to join.
But otherwise, the petition appeal is not maintainable. This writ petition is not maintainable, barred by limitation. On the two occasions, my lord, the first of all, my lord, the Debt Recovery Tribunal, Guwahati, rejected the applications of the my lord, bank. Again, matter went to the my lord, the appellate tribunal at Calcutta. And again, my lord, the dismissal. And this is the third forum wherein my lord, they're trying to my lord, build up the case. Whereas, my lord, law is very clear, it is barred by law. My lord. So on that issue, my lord, the matter can be my lord, disposed of, my lord, the matter may be dismissed. My lord.
No.
We'll have to hear.
Your lordship, mortgage has created.
That's why barred by limitation, the application has been dismissed, right?
Yes.
Therefore, against that they have filed this
Yes, ma'am.
petition. So we'll have to hear him.
Yes,
We'll have to hear him.
subject to my lord, the lordship's convenience on any date, my lord.
Yes, what do you want?
Your lordship, this matter may be taken up on any hearing day, your lordship.
Huh?
Your lordship.
We'll fix it. You come. You please appear in physically.
Yes, your lordship.
It's very difficult.
Yes, your lordship.
I don't know
Your
about
lordship.
you, but I don't know about you, but this code is not compatible.
I'll do your lordship try and I will appear physically before your lordship.
Yes, you agree that it.
Yes, your lordship.
After
Your lordship maybe come up on 15th of July.
15th of May. Okay. As agreed to by land council to the parties, list this matter on 15th. 07.
No, my lord, 15th of July is
15 would be
31st, my lord, July. Ma'am.
Maybe. Yes, your lordship.
31st.
Yes, your lordship.
31st July. Huh?
Development.
You just name it.
Yes, Mukesh,
Heard Mr. M. Sharma, learned counsel for the petition, and Mr. M. Kato, learned DJ.
No, my lord. Here I am appearing on behalf of the
learned
private respondent.
Counsel for the respondents. Mr. Has agreed to learned counsel for this matter on 31st July.
Development.
your lordship, 31st of July.
May it please, lordship. My lord, I have just prepared one brief summary of the case.
Your lordship, is it 31st of July?
Yes, yes.
And my lord,
In this matter, pursuant to your lordship's order, I have appeared. But there is one issue I was discussing with my learned friend. There is a position taken by the union, respondents 1 to 4. And your lordship will kindly have their affidavit for a moment. Page 129.
187.
It starts at
No, 187.
129.
Read petition 187.
Yes. 186, madam.
186.
186, 187, same.
More or less same. I am referring to 186.
Not affidavit. Affidavit.
Affidavit by the union.
186.
In fact,
186.
the affidavits that were filed
By
much before, before I entered into the scene. There is one issue particularly.
100 and
129. The stand of the union is that they have page 129. The last sentence of para 13, madam. The total acquisition compensation of so and so for area measuring so and so acres, that is so and so, etc., was paid to the Deputy Commissioner of Bamdila by the Ministry of Defence. On this, my lord, our affidavit is silent. We'll probably have to take some instruction on this aspect.
No,
Unless my friend has.
no, my lord. This issue was taken up on the last occasion on 19/12/2024, and on the basis of this claim, your lordship has directed that the Deputy Commissioner to file an specific additional affidavit. They have filed it in paragraph 5. They have. I'll just read out the paragraph 5.
Of what? Affidavit filed by the?
Yeah, additional affidavit filed by the Deputy Commissioner. This was filed on 23/4/2025, my lord.
23.
And your lordship, the direction was on 19/12/2024. So, my lord, paragraph 5, my lord. They have taken a categorical stand. Paragraph 5, my lord. May I read, my lord? That the Union of India filed their affidavit in opposition, wherein they stated that the land in question was acquired and even the compensation was released in the favor of the Deputy Commissioner West Kameng District. After perusal of the affidavit in opposition filed by the Union of India, the Office of the Deputy Commissioner West Kameng District re-verified the same, and after re-verification, it has been found that there is no record of acquiring land in respect of the land in question, nor any records pertaining to receipt of the compensation from the Union of India. Therefore, the Office of the Deputy Commissioner West Kameng District, who is the acquiring authority, do not have any records of receiving the compensation amount or acquisition of the land. But this is the specific stand, my lord.
That is an affidavit filed by the Deputy Commissioner. The difficulty is, this is an issue of 71/72.
Yes.
So
And they have
perhaps
said-
some clarification from the government also should be on record. Otherwise, if your lordship proceeds on merit, otherwise there are other issues. Whether your lordship will at this stage at all entertain such a claim. But I am not on
See,
that. not on-
the documents relied by the Union of India is of 1970s, 60s and 70s. So obviously, they simply cannot, Deputy Commissioner may not simply brush it aside that there is no record. Therefore, there was no this thing.
The stand taken in the affidavit, as I find, both the affidavits, is we don't have any records. So that
Otherwise, my lord, the records they have annexed, it is categorically stated that it is maintained by the military unit. No endorsement by the Deputy Commissioner.
No,
And the Deputy Commissioner is the acquiring authority. And these records should be with the Commissioner. And even if it's not there, there should be some endorsement.
I think it's better since we have requested Advocate General. Let them have a say on this. Because obviously, DC may be correct to the extent that there is no record. It may not be there, even if it was acquired. But then let the state, they should
Yes, my lord,
normally take
they can take some time. But then otherwise, my lord, the Commissioner, Land Department, on 13/8/2014, they have already issued an order that they have not, the land has not been acquired. But I have annexed Annex 10.
See, the affidavit filed by the district, the Deputy Commissioner is also authorized, the officer is who has sent the affidavit is the DLRSO. You file and making a stand clear on by the Secretary.
I think that
I think that would be better.
Because
we are not saying that the record is there, they are bluffing. May not be correct. It may be correct that the records may not be there. Right.
perhaps it has to come from the Secretary.
Secretary. Government, let the government take its stand.
But I am appealing for Indian of India, madam.
Yes.
We have filed it and we have obtained some records from the Deputy Commissioner. Whatever we have filed, whatever the records we have annexed in our affidavit in opposition.
You
We
obtain
have
it
got
from the
obtained
Deputy
it from the office of the Deputy Commissioner.
It's very strange again.
Because, yes.
How do we get it? From where we?
Just petition of the annexers. There is nothing on it. This is only by the defense state. And that is also.
They themselves.
From the secretary land management, sorry, man.
Huh?
It is from the secretary land management.
So you are
Just my client informed me, not
Secretary?
land management, my lord. Just my client informed me that they have obtained whatever the documents we have got the original copy after that retyped it and filed it in our affidavit of opposition. Okay, since the advocate general is saying, let them file affidavit, my lord. The time will be clear.
Let me make an endeavor if they can at all trace out something.
Definitely, because it issue is a very serious issue, my lord.
Your
Yeah,
lordship,
because it will have a ramification also.
Yes.
In some other cases in the state. So let them make their stand clear.
this was of a stage, the process
Yes.
started right from 1962. So all those records, we don't even know.
Even before this, the state.
Yeah, government stance should be clear.
Was union territory.
Even before it was a union territory.
Even
Union territory, right. Nepal.
Okay.
Otherwise,
Heard Mr. That is, this is Pathan or what? It's not Pathan.
Not.
Heard Mr. T. Pratik, Land Counsel for the petitioners. And Mr.
I'm Y. Doluman,
Y. Dolo.
Senior Panel Counsel for Union of India,
Senior
correspondent
Panel
number
Counsel
1
for Union of India, respondent Union of India. Next page. Mr. I. Chaudhary, London, Advocate General. Assisted by Mr. S. Tapin, London Council, London Senior Government Advocate. Submits that. No, we'll see. Who is number one?
That 19/12/2024 order direction by your lordship.
Yes,
Maybe.
London also have London
The
Advocate
Deputy Commissioner is filing additional affidavit.
assisted by Spencer and White. Who is number one? Respondent number one. Who is one?
1 to 4 is union.
Okay, then union, then London Advocate. The next one. Considering the affidavit, additional affidavit. No, having considered the statement, stand taken by the Deputy Commissioner West Coming District in the Biocan additional affidavit that after verification and re-verification, there is no record of acquiring the land in respect of the land in question, nor any records pertaining to receipt of compensation from the Union of India by the Deputy Commissioner. The learned advocate general to take, what do we say, steps?
We would like to have specific instructions from the state instead of the deputy.
Instruction from the
government. And if needed, we'll file an affidavit.
If required, the instruction, if required, an affidavit be filed. List matter after 2 or 3 weeks. 2 weeks.
That may be fixed, madam.
Next week.
Next week, after vacation. After the vacation, Malu. I am coming for those division bench matters on 28th. This can be on 28th or 29th.
29?
Which one?
July.
29 July. 29 July.
July.
They will have a consultation with all these discussions.
Okay, as he has
before the vacation, because
you may not have a problem. He may have a problem.
We've been fighting since
Yeah.
last 60 years.
Yes. Okay.
All right.
Like it.